Are we on Cisco?
Are we what?
The Cisco, does it need to be turned on?
Not that I know. Is statewide appearing this morning or?
Well, I thought there was also a private attorney on Martin.
Oh, you know who the attorney is?
Hornsby?
Hornsby, Richard Hornsby.
You're going to do them first, or are you going to do them?
Who's the defendant?
Martin.
Oh, I'm supposed to call him through the telephone. He's gonna appear through the loudspeaker. The
okay.
email that I got.
One of the statewide says they're on right now, so I don't know if we just want to turn it on to make
Okay,
sure.
that's fine. Judge, you gonna add a video conference? You're gonna go to the call button and hit video conference.
It wasn't until second session.
Which case is that?
Welcome to an Econo meeting. You are entering the meeting now.
Their case was second session, but he's still sitting on it.
State, what case is the statewide on?
They are on two different cases. One is
It's second session, Your
it's
Honor.
second
I
session.
haven't had a chance.
One is Bajnath, Vishram.
We don't have that.
I don't have that paperwork.
I believe they're sitting on it, so they've been sitting on it, I believe since 9 a.m. So just wanted to make sure that they knew that their case would be called second session.
Thank you. I'm sorry. I just was checking my audio and video. I'm sorry. I didn't mean for this to be called now.
I believe they're sitting on it, so they've been sitting on it, I believe since 9 a.m. So. Oh.
Did that just loop? Okay. I'm going to disconnect. Because we don't have that paperwork. They didn't call it up right now, so let's figure that out later. Sir, can you please state your name?
Tyler Blue Johnson.
Sir, you are here on a warrant arrest with regards to a violation of probation. I'm appointing the Office of the Public Defender to represent you. In this particular case, bond is set at no bond. Defense, do you waive the reading of the initial charge?
Yes, Your Honor.
All right, thank you. Anything else, State Defense?
No, Your Honor.
All right, thank you, sir. Please state your name, sir.
Anthony Martin. Anthony Martin.
Who's? Okay, so we're going to call this one
Yes,
Narkeith Payne?
Yes.
Is he not showing today?
Marquis Payne,
What's happening with Mr.,
Mr. Payne, we're just calling it so we can.
is he not available today? Narkeith Payne.
Who?
Remember you said he's not coming, so we just need to address it, so.
He's medical? Okay, thank you. So in the case of Narkeith Payne, this is a violation of probation with regards to underlying charges of grand theft and criminal mischief. I am appointing the Office of the Public Defender to represent him. The judge has set this at a no bond status.
Corrections, was it a refusal or?
Medical. Defense, are you waiving?
I will waive the appearance, Your
All
Honor.
right, thank you. Is this the, okay. So is he going to be,
Good morning, Your Honor. This is Lyle Mason. Can you hear me?
good morning. Can you hear me okay?
I can. I would say it's good to see you on the bench, but I can hear you. So good to hear you on the bench, Your Honor.
Good, likewise, thank you. Are you on a video conferencing as well, or just audio?
No, it's just audio at the jail, Your Honor. I'm representing Mr. Anthony Martin.
All right, thank you. All right, we're here on the case of Anthony Martin. Sir, please state your full name.
Anthony Martin.
All right, and sir, you are here on 4 charges. One is count 1, kidnapping. Count 2 is burglary of a dwelling, domestic violence related. Count 3 is robbery by sudden snatching. Count 4 is battery, domestic violence related. I've reviewed the charging affidavit. I find probable cause. Just bear with me a moment here. Counsel, anything you'd like to say before? And
Yes, Your Honor. Your Honor, short of the state moving forward on a proof evident presumption great, the defendant is entitled to bond at an initial appearance. In addressing the proof evident presumption great, I guess first I'd ask if the state's moving forward on that, and then I would like to, 1, address the bond if they're not, and then 2, if they are, well, then we can address that.
all right, State?
Your Honor, according to the Thornton case, which was just affirmed by the Florida Supreme Court, state does not have to prove proof evident presumption great at IA for you to hold him no bond. So state would ask that you hold Mr. Martin no bond, paying an Arthur hearing downtown at a later time.
Counsel?
That was not actually the ruling of the case. The case is that the initial appearance judge on a ruling be re-heard upon at a trial court.
And please forgive me, counsel, I'm having trouble completely understanding. Maybe,
Your Honor, I
maybe
apologize,
you,
Your Honor.
no, it's a
Can you hear me better now?
equipment issue. You are being broadcast through what appear to be speakers in the ceiling here. It's not a clear audio for me. Maybe you can get closer to the mic, or are you on a handset?
I am on a handset. Can you hear me? Can you hear me clearly now?
Let me,
I can hear you clearly.
okay, I hear you better now.
Okay. Your Honor, what I was saying is the ruling of the case was that it is that a trial court can readdress any issues from the initial appearance court, which formerly they couldn't. As to the proof evident presumption great, short of the court finding that he'd be entitled to a bond. With that being said, as the state says that they're not moving forward on that, I'd like to address the setting of a bond. As to the kidnapping charge, I'd like to make it unequivocally clear that the child is actually that of the defendants. There was not a kidnapping in that case. It was the defendant. As to the remainder of the charges, even looking in the light most favorable to the state, this was a domestic battery charge short of a door. And there is no proof evident at all that there was actually a battery that occurred, which makes that a PBL. So that being said, with the kidnapping being that it was his son, this would basically amount to a domestic violence. I would ask that a bond be set in a reasonable amount. The defendant's not a flight risk for himself to New York and had him extradited to Orange County.
So please forgive me. The connection is breaking in and out. It's a little difficult for me to completely understand everything that you are saying. Is it possible for you to come down?
Yeah, I'm readjusting the mic issue. Can you hear me better now? Because I just moved the mic.
It's a matter of it like becoming choppy, coming in and out.
Okay.
And it may not be anything on your side. It may be just on this side.
Understood. What I was just saying is to the bond, if you can hear me clearer now, because I readdressed the mic. Can you hear that?
We hear you. It's that with some, at times it just becomes choppy. So I can't hear.
Understood. Does the court have the link and I could peer via video?
I can email it.
Okay, the state says that they have the ability to do that for you, okay?
Okay, my email, does the state have an email, or can I give my email? I can call back to Denise.
Is it still Lyle at Mason Law?
Yes.
Sent.
Okay, I'll appear I will get on the link and I'll appear momentarily. Give me 5 minutes, Your Honor.
Okay.
All right, thank you.
Can we address another case in the meantime? Yes. You'll please bear with us, sir. Your attorney is going to call in via another link. Who can we address? This is your paperwork, right?
No, that's your copy. It's just, it's a reset from yesterday.
Oh, but everything else is you gave me your paperwork, right?
Yes.
I'm not working off the computer. All right, can we deal with Lynn Sagita?
I get the pen. Your Honor, we reset Ms. George in order to see if she would like to accept the plea. The offer from the state was an adjudication of guilt, credit time served, and no return. The offer is as to the new law violation in case number 2022 MM 4658AO and 2022 MM 3152AO. And she would like to accept and enter a plea of no contest, Your Honor.
I've got a,
Sorry.
the present case I have is 22 MM 4658, and she was out on ROR on a 2022 MM 3152?
Yes, Your Honor, it's an adjudication on both.
Okay. And how much time served is she showing?
She said we can continue and she'll give you the time served.
All right, thank you. And let the record reflect the plea form was signed in open court. Can you please swear her in?
Can you raise your right hand, please? Oh, you can. Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
Can you please state your full name?
Agita Lynn George.
And did you review this plea form with your attorney?
Yes.
You understand the rights that appear on the front of the plea form?
Yes.
You understand you are giving up those rights by entering pleas here today?
Yes.
Do you understand the maximum and minimum penalties for the charges you are pleading here today on?
Yes.
Are you entering the pleas of your own free will?
Yes.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
No.
Do you suffer from any type of mental condition or disease that might affect your ability to think clearly?
No.
You understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes.
And are you satisfied with the services of your attorney?
Yes.
With regards to the charge of trespass on property after warning from an incident of July 11th, 2022, how do you plead?
No contest.
With regards to a charge of trespass on property other than structure or conveyance from an incident of May 12th, 2022, how do you plead?
No contest.
I accept the pleas of no contest, find you are alert and intelligent, understand the rights and the penalties associated with the charges. You are entering the pleas of your own free will, and there are sufficient facts to accept the pleas. At this point, I'm going to adjudicate you guilty on both cases. I'm going to give you credit for time served.
On 22 MM 3152, she has 2 days. On her current case, she has 3 days.
All right, thank you. And so we'll give her credit for time served. I'm going to impose upon you, I'm going to require that you not return to the places where these incidents took place. State, do you have an address?
Your Honor, it's the Orlando International Airport on both.
All right. And so I'm going to require that you not return to the airport for a period of 1 year. I'm going to assess all appropriate court costs and fees. We're going to put those all together, require that they be paid within a 1 year period. Did I address all parts? All right, you have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. Thank you, ma'am.
Okay.
And he should be on visual now, right?
Mason just called. He said he needs about 15 minutes.
Okay, about
Yeah.
15 minutes. So that's on Mr.
He said
Martin.
give him 15 minutes.
Yeah, Mr. Martin, bear with us. Your attorney's going to need about 15 minutes to get up on the system, okay? Again? Yeah, but it's okay. We can do it again.
Okay.
Good morning, sir.
Morning.
And please state your name.
Dennis Hoover.
All right. And counsel?
Your Honor, Mr. Hoover, he did speak, he's not gonna qualify for the, veteran court.
Okay.
So he would like to accept the state's, offer of a withhold credit time served as to the disorderly conduct. And in return for playing to the disorderly, we would ask that you take no action on the out on bond. They're working to try to resolve that case as well.
State, any comment?
No, Your Honor.
All right. And remember, we had a conversation with regards to whether or not the court can withhold and give credit for time served.
Yes, Your Honor.
So it would be a withhold, no credit. Right, it would be a withhold and court costs. Is that your understanding, State?
Yes, Your Honor.
All right. And can you please swear him in?
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
Sir, can you please state your full name?
Dennis Dwayne Hoover.
And sir, let the record reflect the plea form is being signed in open court. Thank you. Sir, did you go over the form with your attorney? Thank you.
He's actually,
Did you go over the plea form with your attorney?
did you go over the plea form with the attorney?
Yes, ma'am. Yes,
Do you understand the rights and the penalties associated with your charge?
yes, sir.
Are you entering the pleas of your own free will,
Yes, sir.
under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
No, sir.
Suffer from any type of mental condition or disease that might affect your ability to think clearly?
No, sir.
Are you satisfied with the services of your attorney?
Yes, sir.
With regards to the charge of disorderly conduct from an incident of July 11th, 2022, how do you plead?
No contest.
I accept the plea of no contest, find you are alert and intelligent, understand the rights and the penalties associated with the charge. You are entering the plea of your own free will, and there are sufficient facts to accept the plea. At this point, I'm going to withhold adjudication on the charge. I'm going to impose all applicable court costs and fees, give you 1 year period to pay on that. With regards to the, I think it was an ROR he had on the possession of cocaine, yes. With regards to the possession of cocaine matter that you are presently out on ROR, I will take no action on that. Please state your name, sir.
Robert Austin Burgos.
You're here on 2 counts. First count is a charge of burglary of structure. Second count is a charge of battery, domestic violence related. I've reviewed the charging affidavit and I find probable, I'm so sorry, this is on a warrant arrest. The judge set the first count, burglary of a structure, at $3,500. I'm appointing the Office of the Public Defender to represent you. With regards to count 2, which is the battery, domestic violence related. Bear with me a moment, please. I'm setting bond at $1,500. You're to have no contact whatsoever with the alleged victim in the case, that is directly or indirectly. That means that you cannot talk to her in person. You cannot text her, email her. try to contact her through any internet or social media platform, and you cannot have any other person try to communicate with the alleged victim on your behalf. You also, that means you cannot accept any communication from the alleged victim at all. You are to maintain a separate residence from the victim. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim at all times. That means from the victim, their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know that they frequent. I don't believe you all live together, but in case you have any possessions at the other person's residence, I will allow you to return one time with the assistance of law enforcement to retrieve any personal property. Is there anything else? State Defense?
No, Your Honor.
No, Your Honor.
All right, thank you. Make sure I don't put that in there. Okay. Please state your name.
Lawrence Ellison.
And sir, you are here on 3 counts. First count is battery, domestic violence related by strangulation. Second count is false imprisonment. Third count is battery. I've read the charging affidavit, and I'm sorry, this is also a warrant arrest. The judge has put this at no bond statuses, but as the initial appearance judge, I will be imposing bonds and conditions of release, as this may be modified by the first appearance judge according to the warrant. If I haven't said it already, I'm appointing the Office of the Public Defender to represent you. I see that you have a question. Would you like to ask the attorney?
About the case, they got me in domestic. I don't even know the girl.
Hey, stop. I already told you to stop. Thank you, Your Honor.
All right, may I continue, counsel? Is it okay, or is there?
Yes, Your Honor.
Okay, thank you. And so with regards to count 1, I'm setting bond at $7,500 to maintain a separate residence, to have no contact whatsoever with the alleged victim in the case.
Listen to you, sir.
Can you hear me okay? Okay, and if you can't, just let me know and I'll, all right. To have, maintain a separate residence from the alleged victim, to have no contact whatsoever with the alleged victim. That means you can't talk to the victim in person, you cannot call them, text them, email them, you cannot use any other type of internet platform or social media platform to communicate with them, and you cannot accept any communication from the alleged victim either. You must consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You must maintain a distance, did I already go through the 500 feet? No, you must maintain a distance of at least 500 feet away from the alleged victim. That means 500 feet away from the person, their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know they frequent. With regards to count 2, I'm setting bond at $1,000. Count 3, I'm setting bond at $500. Anything else? State Defense?
No, Your Honor.
All right, thank you, sir.
That's what the bomb is?
Please state your name.
Janie Holland.
I had a question. Does she qualify for PTR?
She did not initially, Your Honor.
Okay, thank you. You are here with regards to a charge of battery on a person 65 years of age or older. I've reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you. Going to set the following bond in terms of release. A bond is set at $1,500. You are to maintain a separate residence from the alleged victim. You are to have no contact whatsoever with the alleged victim. That's direct or indirectly. That means that you cannot talk to them in person. You cannot call them, email them, text them, or try to communicate with them through any internet or social media platform. You also cannot have a third person try to communicate with them on your behalf. You can return one time with the assistance of law enforcement to pick up personal possessions at the residence. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You are to maintain a distance of at least 500 feet from the alleged victim. That means 500 feet from their person, their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know that they frequent. Anything else, state or defense?
No, Your Honor.
Nothing.
Would you please ask the attorney first? Thank you.
Is she there? Not go back. You gotta go with this. You can keep it, but you cannot go back. Thank you.
All right, thank you, counsel. Please state your name, sir.
Kevon Lawson.
This has two cases, correct? Sir, you're here on two matters. First is an arrest affidavit with regards to charges, with regards to a warrant arrest on charges of domestic battery by strangulation and false imprisonment. I'm appointing the Office of the Public Defender to represent you with that. Second is a matter of an arrest affidavit of battery dating violence. I'm appointing the Office of the Public Defender to represent you on that matter as well. With regards to the first warrant arrest affidavit on the matter of battery by strangulation, I'm setting bond at $3,500. You are to have no contact whatsoever with the alleged victim in the case. That means that you cannot talk to them in person, you cannot call them by the telephone, email them, text them, use any type of internet or social media platform to try to communicate with them. Also, you cannot try to get communication via a third person. Okay. They have a hearing assistance device. Can you hear me now? Let's do a test here. Do you hear me clearly?
Yes, sir.
All right. If at any time you can't hear me, let us know, okay?
Yes, sir.
And so let me just, did you hear what I said before?
No, sir. Actually, I didn't.
Okay, then let me go back and repeat this, okay?
All right.
So you're here on two separate cases. One is an arrest affidavit with regards to a charge of battery, domestic violence-related by strangulation. Second is a matter of false imprisonment. This is a warrant that was signed by a judge. Second is a arrest affidavit with regards to the charge of battery dating violence. I have reviewed that affidavit, and I find probable cause. With regards to the first matter on the warrant, I'm setting the following bonds and conditions. With regards to the charge of battery, domestic violence related by strangulation, and I don't know if I said it now, but I am appointing the Office of the Public Defender to represent you on these matters, okay?
Sir, I have a question.
Would you run it by the attorney first, please?
It's a battery. Yeah. So there's three. He's going through all three right now. Okay, Your Honor, thank you. He's asking if he has three charges.
Okay, yeah.
And there's three. I explained you were going through each one.
Okay, so with regards to the charge of battery, domestic violence related by strangulation, I'm setting bond at $3,500. You are to have no contact whatsoever with the alleged victim in the case. That means that you cannot talk to them in person, you cannot telephone them, you cannot text or email them, you cannot use any type of internet or social media platform to try to communicate with them, and you cannot use a third person to convey communications on your behalf. I'm going to require that you maintain a separate residence, that you consume or possess no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim. That means 500 feet away from the person, from their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know that they frequent. With regards to count 2, the false imprisonment, I'm setting bond on that charge at $500. With regards to the other matter, the dating violence, I'm setting bond at $2,500. Same conditions as the other one. You're to have no contact whatsoever, directly or indirectly, with the alleged victim in the case, maintain a separate residence, consume or possess no alcohol or non-prescription drugs, control or possess no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You're to maintain a distance of at least 500 feet away from the alleged victim. That means from the individual, their residence, their vehicle, their place of employ, place of worship, place of education, and any store that you know that they frequent. Anything else, State Defense?
No, Your Honor.
This don't make no sense, though.
I have to speak to the attorney.
Please state your name.
My name is Juan Leon Lopez.
All right, and you're here with regards to a charge of aggravated battery on a person over the age of 65 with a deadly weapon. State, in reviewing this affidavit, I was trying to find the deadly weapon. What I see, and maybe I'm misreading it, I'm seeing a telephone, a cell phone?
Yes, Your Honor. Standard stands and didn't find PC either for what was currently arrested. So we just asked for ag bat on a person over 65.
You're modifying the And do you have a statute or section number for Madam Clerk?
I'm pulling it right now, Your Honor. What's the verbiage, Judge? I can write it.
It's just aggravated battery on the person over the age of 65. In the meantime, I'm appointing the Office of the Public Defender to represent you at this time. What's happening is the Assistant State Attorney is looking for a statute number, section number with regards to the charge. It's being modified in order to delete the matter of a deadly weapon. Do you understand what I've said so far?
Mm-hmm.
So just bear with us a moment.
Okay, it will be an F3, 784.04, sub 2, sub C, and that's battery on a person 65 or older.
So it's 784.0
8, sub 2, sub C.
sub 2 sub C. All right. And so with regards to the charge of aggravated battery on a person over the age of 65, I have reviewed the charging affidavit and I find probable cause. I'm setting bond at $1,500. You're to have no contact whatsoever with the alleged victim in the case, directly or indirectly. That means that you cannot talk to them in person. You cannot call them. You cannot text or email them. All right, you cannot text or email them. You cannot try to use any type of internet or social media platform to communicate with them. And you cannot have a third person try to communicate with them on your behalf. You can return one time to the residence with the assistance of law enforcement to pick up any personal belongings. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You are to maintain a distance of at least 500 feet away from the alleged victim. That means from the person, from the residence, their vehicle, their place of employ, their place of education, their place of worship, and any store that you know they frequent. I don't know if DCF may be involved in this or may become involved in it, so in case the Department of Children and Families institutes some type of requirements for you with regards to children, I'm going to require that you comply with the requirements of the Department of Children and Family. Anything else, State Defense?
No, Your Honor.
Please state your name.
Emmanuel Sansolar.
Oh, Your Honor, I'm sorry. On the previous case, you did give a one-time return, correct?
Yes.
Okay, just wanted to know.
Please state your name again, sir.
Emmanuel Sansolar.
Thank you. You're here with regards to a warrant on 4 counts. Count 1 is battery, domestic violence via strangulation. Count 2 is battery, domestic violence. Count 3 is assault, domestic violence. Count 4 is criminal mischief. I'm setting the following bonds and conditions on this case. I'm appointing the Office of the Public Defender to represent you at this time.
Yes, sir.
With regards to the count 1, battery, domestic battery via strangulation, I'm setting bond at $7,500. You are to have no contact whatsoever, directly or indirectly, with the alleged victim in the case. That means that you cannot talk to them in person, you cannot call them by telephone, you cannot email them, text them, use any type of internet or social media platform to communicate with them, and you cannot have another person communicate with them on your behalf. You are to maintain a separate residence if applicable. You can return one time with law enforcement to retrieve personal belongings. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You are to maintain a distance. Did I already do the 500 feet, Counsel?
No, Your Honor.
I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim at all times. That means 500 feet away from them, from their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know they frequent. With regards to count 2, battery, domestic violence related, I'm setting bond at $2,500 with the same conditions I just recited to you with regards to the no contact, maintain separate residence, no alcohol, drugs, weapons, maintain a distance of at least 500 feet away from them. With regards to count 3, assault, domestic violence related, I'm setting bond at $1,000, same conditions as the other 2 counts. And then with regards to the last count on criminal mischief, I'm setting bond at $100. Anything else, State Defense?
No, Your Honor.
All right, thank you, sir. Please state your name.
Douglas Edward Irvin Switzer Thomas.
Thank you. You're here with regards to a charge of aggravated battery on a pregnant person. I have reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. With regards to this matter, I'm setting bond at $3,500. You are to maintain a separate residence from the alleged victim. You can return one time with the assistance of law enforcement to pick up any personal belongings. You are to have no contact whatsoever with the alleged victim in the case, directly or indirectly. That means that you cannot talk to them in person, you cannot telephone them, you cannot email or text them, and you cannot use any other type of internet or social media platform to communicate with them. That also means that you cannot accept communication from them. I'm going to require that you consume or possess no alcohol or non-prescription drugs, and that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim at all times. That's 500 feet away from them, from their residence, their vehicle, their place of employ, their place of education, their place of worship, and any store that you know that they frequent. There is a possibility that DCF may be involved in this matter. In case they do become involved and put some type of order for you to follow with regards to the children, I'm going to require that you comply with any requirements imposed by the Department of Children and Family Services. Is there anything else, State Defense?
No, Your Honor.
All right, thank you.
Your Honor, I've been informed by Mr. Mason that he is back on the link.
Okay,
So whenever Your Honor is ready, if you would log back on to Cisco.
all right. Let's take care of this gentleman, then if we can bring the other Mr. Payne back. Okay? Please state your name.
Eamon Thomas.
Sir, you're here on a couple of matters. One is a warrant, a capias with regards to a failure to appear for a status hearing on June the 3rd, 2022. This is with regards to an underlying charge of possession of, and I'm probably going to mispronounce it, butylone. The judge has set that at a no bond status. You're also here on a warrant with regards to a charge of battery, domestic, related by strangulation. I'm setting bond on that at $2,500. You're to maintain a separate residence from the alleged victim. You're to have no contact whatsoever with the alleged victim.
Oh, I have no question.
Okay,
He just had.
no problem.
No.
You may return one time with the assistance of law enforcement if applicable to retrieve personal belongings. With regards to no contact, you cannot talk to them in person, you cannot telephone them, you cannot email or text them, and you cannot use any other type of internet or social media platform to communicate with them, and you cannot have another person communicate with them on your behalf. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that to maintain a distance of at least 500 feet away from the alleged victim at all times. That means from them, from their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know they frequent. There's a possibility that DCF may become involved here, and so I'm going to require that you comply with any requirements that the Department of Children and Families imposes upon you. I also see that you are here with regards, or that you are out on pretrial diversion with regards to a possession of a controlled substance, possession of drug paraphernalia.
PTD has been revoked earlier, Your Honor.
So say that again?
PTD was revoked back in 2021.
All right.
He's no longer on PTD.
He's no longer on PTD?
No.
When PTD was revoked, was a bond in, because I'm just showing PTD, so was a bond put in place, or?
PTD has nothing to do with his bond. It was just the offer from the state at the time. So his bond never would have been revoked or.
Because it says bond amount, NA, so there was never a bond amount apparently before, at least not on this document I'm seeing.
I think it was it released once he entered into pretrial diversion? I don't know, Your Honor, because I think the failure to appear is on the same case.
Yeah, there was a bond
There
on
was a
the
bond?
case. It was discharged a day
Right.
later when he signed the contract for.
So it
Pretrial
was
diversion.
released once he entered into pretrial diversion.
Okay, so is there an indication that he was complying with PTD or that he was?
I don't have any information on that, Your Honor.
The only thing I saw that he had left to do, I believe, was to pay his fees. I saw the certificate of awareness that he needed to complete that was uploaded in our system, Your Honor. But I believe it was he had to pay the court fees that was issued, was what I saw. I don't know if you see anything different.
All I have is that he didn't complete the requirements. I don't have anything within our system of him completing anything.
Yep. So all I saw was the certificate. They wanted the certificate for drug awareness, which was done. It was the fees. I think it was like $150 that was not paid, Your Honor.
That's on the 6002 case, correct?
Yes, Your Honor.
So he did the substance abuse awareness, which was uploaded, and then the other condition was the cost. He had to pay the fees through the clerk, which he did not pay the fees to the clerk, Your Honor. So that was the last condition he did not meet.
When I look at it's 2020 CF 6002AO, is that correct?
Yes.
And when I look at that, I see that apparently there was a capias issued for failure to appear. I see an arrest affidavit, and then I see nothing else in this system. The file is showing as inactive.
I think it goes inactive once they enter pretrial diversion, Your Honor. Once they enter pretrial diversion, the bond's discharged, and the case goes inactive, even in our system. I think the failure to appear for that case is what opened the case back up in our system.
I just found more. State, are you finding anything here?
I mean, it's still an open case, but as defense stated, it stays closed when they enter PTD, and then when they get rejected from PTD, it gets reset on the trial docket. But given that it's just a drug-related case, and he's already being held no bond on another failure to appear for a drug-related case, state's requesting no action at this time.
I believe it's the same case, right?
Huh?
Yeah, it's the same case. The failure to appear is the same case as the out on bond, Your Honor, if I'm not mistaken.
No, it's not.
It's separate?
Separate cases.
Oh, okay.
All right. I've got more questions than answers with regards to the matter that he was out on PTD. So at this point, I'm just going to take no action on it.
Okay.
Thank you, sir.
You're gonna have to wait that way.
Correct. But I,
Or you can see if the attorney can get you in there quickly.
which one? Did we address all matters with regards to Mr. Thomas?
Yes, Your Honor. Thank you.
Okay.
Since it's no bond. Martin.
Welcome to an Econo meeting. You are entering the meeting now.
Welcome back, sir. Can you please state your name again for the record?
Anthony Martin.
Thank you. All right, counsel, I can see you. Let's see if we can hear you.
Can you hear me now?
Yes, we can hear you.
Perfect. Thank you, Your Honor.
All right. Go ahead.
Okay, Your Honor, what I was stating on the phone that wasn't going through is that the court, in this case, the kidnapping charge, which would be the concerning charge, the state, in good faith, I don't believe is going to be going forward at any time on a proof evident presumption grade. This basically boils down to what is a domestic violence case. The child in this case was in fact the defendant's. As the remainder of this case, it's a domestic battery charge with the breaking of a door. I don't believe the state at any time would be going proof evident presumption grade, so I don't necessarily be asking the court to defer. With that being said, this defendant's not a flight risk. He turned himself into the New York State Jail. He's been sitting in Queens. He was transferred to Westchester County Jail. He was then flown to Orange County Jail. The this defendant's been in jail now for a considerable amount of time. He's not a flight risk. The court can put in a no contact order, and he'll be asking if the court can enter a reasonable bond in this case. If the state thereafter, for some reason, decides that they want to go forward on a proof evident presumption great, they could always file a motion to revoke the bond. I just think in this case, and the case law that the state was citing, it gives the court the discretion to actually, in fact, enter a bond at initial appearance.
State?
Your Honor, state would ask that you do set count 2, since it is a first-degree felony that's punishable by life at no bond. This is not going to be my case eventually as it boils down to the trial court division. However, under the Supreme Court and the Thornton that state cited earlier, this court does not have to find proof evident presumption great today to be able to hold the defendant no bond pending an Arthur hearing at a later time. And that has been affirmed by the Florida Supreme Court agreeing with the 4th DCA. So state is asking that you set no bond on count 2. As it is a first-degree felony that is punishable by life, the victim is proceeding with prosecution, and information has not been filed to date yet. However, there have been charges been put in our system.
Please forgive the interruption. You're saying you want a no bond on count 2? I'm showing count 2 as burglary of a dwelling.
With assault or battery therein, Your Honor. It's a F1 PBL.
Okay. And you're saying that that is, it should be no bond because?
Because it is a first-degree felony that is punishable by life, and under the Florida Supreme Court, this court can hold him no bond without a finding of proof evident presumption great, due to the affirmation of the Florida Supreme Court in the Thornton case. The victim is cooperative, does want to go forward, and does fear the victim or fear the defendant, as he did break into her house, commit a battery, and then allegedly take the child, who I believe is approximately 10 months old. There has been a warrant. Probable cause has already been found by another judge. So state's just asking that you set a reasonable bond on 1, 3, and 4, and set 2 at no bond, to let this be heard at an Arthur hearing later downtown.
All right, thank you. And response, Mr. Mason?
Yeah, that's my issue with this is that as the state said, this case has been open for a considerable amount of time. There haven't actually even been filed charges, let alone that they're an intent to go forward on a proof evident presumption great. And what the court, what the state is citing is a correct articulation of the Thornton ruling, but it doesn't say that the court shouldn't or can't. It says that it has the discretion to. And what I was asking this court to do is use its discretion, read the short affidavit that's there, take into consideration the fact that at worst this is in fact a domestic violence. If the fact that there is any proof or that the defendant did slap, again, it's not choke, not hold, not strangle, not stab, not shoot, not kick. It's an allegation of a slap. And this defendant, there is no circumstances in which I believe the state would in good faith go forward. I understand the state wants to defer, but this is just a gentleman sitting in jail. If at some point the state files actual charges and then wants to readdress the bond, then I would understand what they want to do. But at this point, based on our Constitution, the defendant should be entitled to a bond to be released. And there are conditions that are available to keep the victim or concerns at bay, is there can be a contact order. If the defendant contacts them, they can immediately arrest the defendant. And I've just asked that the defendant, who's now been in jail for a significant period of time in different states, flown from a different state to here, and now is facing at least another week if we have to do another bond because we have a weekend coming up, be given some type of reasonable release.
Final word, State?
Your Honor, counsel citing that it wasn't a shooting, a kicking, or whatever else. For a battery, it has to be an unwanted touching, as Your Honor knows. And allegedly there was a push and I believe a slap and then several bruises throughout the victim's body. There also was the burglary of him breaking down the door. State's concerned that a no contact order is not sufficient as she was behind a locked door and he forced his way into a home that he had no right to be in. State is concerned for this victim's safety, is concerned for the child's safety. And this allegedly occurred the end of May, I believe. So state's still well within time to charge. Also, state would disagree with counsel's saying that he doesn't believe the state is going to go forward on whatever charges. Respectfully, that's not his decision. So given that the Florida Supreme Court and the legislator had said this can be held no bond without proof of reception grade at this time, state's asking for that due to the safety of the victims and the community, believing that a no contact order is not going to be sufficient. And he was in New York, so state is concerned that he may not stay within this jurisdiction, as he does have, I believe, other history from the New York jurisdiction.
All right, thank you. Please bear with me a moment.
Your Honor, I do have that Florida Supreme Court affirmation if you would like to see it.
Actually, yes.
And again, John, I don't disagree that the Supreme Court affirmed that the court can, but it also affirms that the IA definitely, absolutely has the discretion to issue a bond despite a no bond warrant being issued.
Okay, thank you. Is this your copy, or?
No, Your Honor, you can keep it.
Oh, all right, thank you very much. All right, and so the defense is not arguing against that point from the state. Unfortunately, I was just reviewing the affidavit that was submitted in request of the warrant, and my dilemma is that I am basically a visiting judge sitting here temporarily trying to maintain status quo on cases as they go through the process. I don't have the ability to have the attorneys, the state, for example, who's going to be dealing with this on a more permanent basis. I don't know who the judge is going to be dealing with this on a more permanent basis. And so I am left with few resources. And so at this point, I would prefer to have these matters heard for the judge who's going to be dealing with this case on a more permanent basis. So that being said, with regards to the count one kidnapping, I am setting bond at $3,500 to have no contact with the alleged victim, to maintain a separate residence from the alleged victim. With regards to the robbery by sudden snatching, the judge had set that in the bond at $10,000. I will keep that. With regards to the battery, domestic violence related, I am setting bond at $3,500 to maintain a separate residence from the alleged victim, to have no contact whatsoever with the alleged victim. That means that you cannot talk to her in person, telephone her, email her, text her, use any type of internet or social media platform to communicate with her, and you cannot use any other third person to try to communicate on your behalf. I'm going to require that you consume or possess no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim, and that would be 500 feet away from their person, from their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know that they frequent. There is a possibility that the Department of Children and Families may become involved in this matter. If they enter in any type of requirements for you, I'm going to require that you comply with any requirements that are put in place by DCF. With regards to count two, I am going to leave that at a no bond status. Mr. Mason, you indicated that it would take about a week to try to get that heard. Do you know who the...
Just simply because of the time, that's Wednesday now, and that's a week.
Do you know who the judge is in this division?
Judge Blackman in Division 10. Blackman in Division 10.
Judge Blackman. Is there something that we can do to try to expedite that so that perhaps he can get before Judge Blackman this week?
I mean, I'm gonna email the JA. Judge Blackman's a good judge and he'll give us the time. I definitely appreciate the offer. I mean, and I would absolutely take it, but yes, us emailing the judge would probably be sufficient. If you were emailing the judge saying that, there's a bond motion coming, that might be additional help, but
Okay.
that would be the extent.
I'll request that the state do that with the state in that department, and I'll request that Madam Clerk send a heads up to Judge Blackman, letting him know that this matter, you're going to try to get this matter heard before him ASAP.
And I appreciate that very much, Your Honor. Thank you.
You're welcome, sir. You've always been very professional when you appeared before me, and I appreciate that.
Thank you, Your Honor. Good to see you again.
See you. Thank you.
Thank you.
Did we address all matters, Counsel?
I believe so.
And State, did we address all matters?
Yes, Your Honor.
All right. Sir, thank you very much.
Thank you, Your Honor.
Okay. And so I'm going to disconnect you, Mr. Mason. You have a good day. Thank you.
Your Honor, Christy Fibo, refuse.
Okay. With regards to the case of Christy Fibo, I'm appointing the Office of the Public Defender to represent her. I've reviewed the charging affidavit, find probable cause.
And I will waive the appearance, Your Honor.
Thank you. This is a two-count matter. Count one is damage of property, criminal mischief. Bond on that is set at $250. With regards to count two on battery, domestic violence related, I'm going to set bond at, and I'm sorry, there's two counts of battery. So I'm setting bond on each one of those counts at $1,500 each. And with regards to both of those matters, I'm going to require that they have no contact directly or indirectly with the alleged victim in the case, that they maintain a separate residence, that they consume or possess no alcohol or non-prescription drugs, that they possess or control no weapons or firearms. Any weapons or firearms within their control or possession are to be handed over immediately to law enforcement upon their release from custody. They may return one time with the assistance of law enforcement, if applicable, to retrieve personal belongings. I'm going to require them maintain a distance of at least 500 feet away from the alleged victim, that is from the person, their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that they know the alleged victim frequents. Anything else, State Defense?
No, Your Honor.
Okay. Yes.
He did.
Thank you. No.
Okay, thank you. Please state your name.
Roy Villapuchi.
Thank you. Sir, you're here with regards to a charge of battery causing bodily harm. I'm appointing the Office of the Public Defender to represent you.
Your Honor, he does qualify for pretrial release, and state has no objection.
Thank you. This is domestic related. I am going to have him released through the pretrial release program. As conditions of release, I'm going to require that you have no contact whatsoever with the victim in the case. Means you cannot talk to her directly, you cannot email, text, use any type of internet or social media platform to try to communicate. You cannot have a third person try to communicate on your behalf either. That means you also cannot accept communications from the alleged victim. I'm going to require that you consume or possess no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. As I said, you are to maintain a separate residence. You may return one time with the assistance of law enforcement to pick up personal belongings. You must maintain a distance of at least 500 feet away from the alleged victim. That means 500 feet away from them, from their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know that they frequent. All right, anything else, State Defense?
No, Your Honor.
Please state your name.
Ashley Michelle.
You're here with regards to a matter of charge of battery, domestic violence related. I have reviewed the charging affidavit and find probable cause. Here? This?
Yes.
And that's what opens that?
Yes.
Don't you? Who normally does the, yeah, I do. Yeah. Who normally does the button? Oh, because like the other days, then the button, got it. Okay. I don't know if I said it, but I'm appointing the Office of the Public Defender to represent you at this time. I see that we have an individual in the booth. Would you please swear him in?
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Please state your name for the record.
Malcolm Shabazz.
I'm so sorry.
Malcolm Shabazz.
Thank you.
May I inquire?
Yes, please.
Good morning, sir. Can you please state your relationship to Miss Michelle?
We have a child together, which is Micah.
Are you afraid of her?
No,
Has anything like this ever happened before?
no,
Do you believe drugs or alcohol were involved?
not at all.
Do you want to have contact with her while this case is pending?
What do you, as in, well, we have to figure out something with our child, so I don't think I have a choice.
Okay.
I'm so sorry. I was handed a document in the meantime. I didn't hear the last question or response. Please forgive me.
I asked him if he would like to have contact with her while this case was pending.
Yeah, and I said I don't know if I have a choice, being that we have a child and are sharing custody.
And do you reside with Miss Michelle?
No, ma'am.
All right, thank you. Is there anything else you'd like to tell the court?
Yeah, I think, well, Ashley Michelle is a great mother. I don't feel threatened. I don't feel anything. I think whatever happened that night, it was just an accident, and I don't think she should be here.
One more question, Your Honor, given the updated information. She qualifies for a program pretrial release, meaning she could get out of jail without paying money to get out, but she would be supervised by the staff here at the jail to make sure that she was complying with any conditions that this court set. Does that sound okay to you, or is that something that you would object to?
No, yeah, she shouldn't. I don't think she should have to pay money.
Okay. No further questions, Your Honor, and state has no objection to PTR.
And defense, any questions? Bear with me a moment, please. All right, and so at this point, the court will release you through the pretrial release program. As conditions of release, I'm going to require that you consume or possess no alcohol or non-prescription drugs. I'm going to require that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You are to have no hostile contact with the alleged victim in the case. And so if, for example, someone calls law enforcement and says there's an agreement, there's an argument, a fight or something, then this situation is going to get a lot worse. Okay? Anything else, State Defense?
No, Your Honor.
All right, thank you.
Thank you.
Your Honor, Brian Torres, mental health.
Thank you.
I will waive the appearance, Your Honor.
Okay, and I'll appoint the Office of the Public Defender to represent him. And,
Your Honor, just for the record, there have been several other prior BAT DVs and violations of injunctions for Mr. Torres. The latest being there's a 2022 non-arrest BAT DV, same victim. There's a 2020 misdemeanor non-arrest violation of a domestic injunction, 2022 misdemeanor BAT DV, 2022 misdemeanor BAT DV, 22 BAT DV, 21 violation of a domestic injunction, 17, 16, 16, 16 BAT DV. Those cases were declined to prosecute or no billed due to the victim being unwilling to prosecute. State just wanted to let you know regarding the consistent nature of these kind of calls between these victims and these defendants.
Your Honor, I just point out, if you read the arrest affidavit, it is actually his mother. He was parked in the driveway. She actually stated she is not willing to prosecute. So I just ask that you consider that factor when setting the bond.
all right, thank you. And so, with regards to this matter, I've reviewed the charging affidavit, find probable cause. And I am going to set bond at $7,500 to have absolutely no contact, directly or indirectly, with the alleged victim in the case. I don't believe they reside together. So I'm going to require that he possess or consume no alcohol or non-prescription drugs, that he control or possess no weapons or firearms. Any weapons or firearms within the control or possession are to be handed over immediately to law enforcement upon the release from custody. I'm going to require that he maintain a distance of at least 500 feet away from the alleged victim, their person, their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store the defendant knows the alleged victim frequents. All right, thank you. Please state your name.
Ryan Anthony Herron.
Sir, you are here with regards to a warrant arrest with regards to a violation of probation, underlying charge of possession of a firearm by a convicted felon. I'm appointing the Office of the Public Defender to represent you. And defense, do you waive the reading of the allegations of violation?
Yes, Your Honor.
And the judge has set that at a no bond status. Thank you.
I'll probably buy one on my own money. You know Mario.
Your Honor, the Cavius Burton, mental health.
All right, thank you. I'm appointing the Office of the Public Defender to represent him.
I will waive the appearance, Your Honor.
All right, thank you. He's here on a couple of matters. First is a warrant with regards to a violation of probation. And that has been set at a no bond status. Second is a matter of a grand theft third degree, a motor vehicle that is being set at a $1,000 bond. Then there is a matter of a driving with a suspended license, subsequent offense, that is being set at $500. Anything else, State Defense?
No, Your Honor.
Please state your name. Sir, you are here on a warrant with regards to a violation of probation for an underlying charge of delivery of a controlled substance. I'm appointing the Office of the Public Defender to represent you. And this is with regards to violation of the order of probation by failing to report to the probation officer as directed, failing to report for the month of June 2022. That has been set at a no bond status. All right, thank you. Yes, sir?
Regis Garcia, behavior.
Okay.
We'll waive the appearance, Your Honor.
Thank you. She's here on a few matters. She is here on a warrant with regards to, I'm sorry, she's here on a violation of probation. This is one I had. Is this an on view?
Yes.
All right. So let me backtrack. She's here with regards to two charges. One is possession of cocaine. The other is possession of drug paraphernalia. I've reviewed the charging affidavit, find probable cause. Possession of cocaine bond is $1,000. Possession of drug paraphernalia bond is $500. She also has an on-site violation of probation, and I'm leaving that at a no bond status. She's also out on bond with regards to charges of destruction of evidence, possession of cocaine in case number 2022 CF 2551. She's also out on a bond with regards to a charge of driving while license suspended or revoked with knowledge in case number 2022 CT 420AW. I'm going to revoke both of those bonds and set them at no bond status.
We haven't filed the first one.
Your Honor, Henry Johnson, refuse.
Okay, thank you. With regards to the matters of Mr. Henry Johnson, I'm appointing the Office of the Public Defender to represent him at this time. He has a warrant with regards to, and are you waiving his appearance?
Yes, Your Honor.
All right, thank you. With regards to the first matter, it's a warrant on a violation of probation with regards to underlying charge of aggravated assault with a deadly weapon. And are you waiving the reading of the affidavit?
Yes, Your Honor.
The judge has set that at a no bond status. Second matter is a matter of a failure to report. Counsel, you waive the, this is on a warrant arrest. It's a,
I will waive the reading, Your Honor.
thank you. And that's in case number 2022 CF 4692. And the judge has set that warrant at a no bond status.
Your Honor, he is entitled to a bond. It's to be set at IA.
We're talking about 2022 4692?
Yes, Your Honor, he is entitled to a bond, given the nature of the charge. State would just ask that you set a reasonable bond.
Setting bond at $7,500.
State would ask for the condition to report to the sheriff's office within 24 to 48 hours after release.
If he meets the bond condition, he is to report as required within 24 hours of release from custody.
Thank you.
Please state your name. Sir, you're here on a couple of matters. I'm appointing the Office of the Public Defender to represent you.
I got a private attorney.
You have a private attorney, sir? Okay, so let me read these matters to you. With regards to one matter, it's a warrant arrest on a violation of probation with regards to an underlying charge of grand theft motor vehicle. The allegations of violation of probation involve leaving your county of residence without first procuring the consent of probation officer. Second is a violation of condition by failing to live without violating any law by committing the criminal offense of larceny, petty theft, first degree, $100 more or less than $750. The judge has set that at a no bond status. With regards to the second matter, it is a warrant arrest for violation of probation with regards to underlying charges of burglary of a conveyance and burglary of a conveyance. Violations of conditions are a violation of probation by leaving the county of residence without first procuring the consent of the probation officer. Also, violation of condition number 5 by failing to live without violating the law, by committing the offense of larceny, petty theft, first degree, $100 or more or less than $750. The judge has set that at a no bond status. Do you understand what I have said, sir? Yep. All right. Thank you, sir. Please state your name. And I'm so sorry, please repeat the last name. Thank you. Sir, you're here with regards to a violation of probation warrant. I'm appointing the Office of the Public Defender to represent you at this time. This is with regards to an underlying charge of driving under the influence. And defense, you waive the reading of the affidavit at this time? Yes, Your Honor. All right. And sir, the judge has set that at a no bond status. All right. Thank you, sir. Okay, very good. Case are we starting with?
Good afternoon, Your Honor.
Good afternoon.
H. Manuel Hernandez, on behalf of Julio Padilla Camacho. It's good to see you. Haven't seen you in a long time.
Good to see you.
Who is
All right.
present and
Just
someone's going to be assisted with a court interpreter? No habla inglés, ¿verdad?
He needs an interpreter?
Good afternoon, Your Honor. This is Laura Royo, State Certified Interpreter and previously sworn.
Good afternoon. We're here on case number 2020 CF 299AO. And counsel, please proceed.
Yes, Your Honor. Again, H. Manuel Hernandez on behalf of Mr. Padilla. Mr. Padilla is a resident of South Dakota, and that's where he's been living. He actually, in terms of the relationships of these two charges, one is the showing obscene material to a minor, and the other one is using a two-way communication device unlawfully. Both F3s, one's an L1 and one's an L4. He was in South Dakota, unaware of charge being filed, eventually became aware of him. He was taken into custody in April of 2022. The events underlying the facts of the charges here happened in 2018. So it took the state a while to actually get around to filing the charges. He was arrested in April of 2022. The judge in South Dakota decided Florida was taking too long, gave him a bond of $5,000. He was out on bond and without any incident. Once the paperwork came through, she took him back into custody, and he just arrived last night. I'm requesting, Your Honor, a bond according to the schedule. As I read the schedule, it's about $1,000, but I never understand the bond schedule, to be honest with you. So, that he be allowed to return to South Dakota because that's where he lives and works. And he is currently cohabitating with a woman in South Dakota, and they have 3 children together. One's 2 boys, 14 and 10, and a little girl who's 8 years old. And I'm requesting that he be allowed to return to his home and have contact with his own children As I understand, the state is asking that he not have contact with any other children, and we have no objection to that. So I'm asking for the bond be posted. I have a bondsman on standby, and that he, again, be allowed to return to South Dakota, which is where he lives. And he's retained my services, and I'll be representing him, of course, and he'll be in contact with me for anything. And he understands that he has to return for any court proceedings.
State?
Your Honor, Mr. Padilla is entitled to bond on both counts. They are both F3s. State's only concern is, since he will be returning to South Dakota, his willingness and ability to come back to Florida for court proceedings. I do believe the bond schedule for count 1 is $1,000 per count, and same with count 2. State has filed an information, so state would ask that you set it double what the bond schedule, which is typical for if they're not from the area and don't have community ties. So state would ask for $2,000 per count.
Is the state requiring any, or requesting any conditions with regards to contact with minors?
Your Honor, state has no objection to him having contact with his own biological children. However, state would request no contact with any other children under the age of 18.
Any response, counsel?
Not really, Your Honor. The state's being, it's not being unreasonable. My understanding is the way you post a bond on the first count, and then the other one is 150. It just means he has to come up with more money on the 2,000. He has to come up with 200 instead of 100. You put 150, you have to come up with 100. So we have no objection if that satisfies the state and the court. We have no objection. Again, I have a bondsman and the family's on standby, ready to try to post a bond to get him out of jail, so he can get back to work and back to his family.
The state, is he showing any prior failure to appears anywhere?
Here, I don't have any other prior failures to appear. I do have some prior history out of South Dakota that was driving related and drug related. State's main concern is the lack of community ties, Your Honor.
I'm so sorry, what was the last sentence?
State's main concern is just the lack of community ties, given that South Dakota isn't even in the tri-state area. It's pretty far and would require a plane ride back instead of just a short drive. So state just wants to, and I'm sure that Mr. Padilla is going to come back to finish this case out.
And counsel, if you can answer this, any information as to how long he has been a resident of South Dakota?
My understanding it's about 5 years, but let me check, Your Honor. Okay. He's been in South Dakota for 5 years, and he came from Puerto Rico to South Dakota, so he's a U.S. citizen. And I forgot if I mentioned, he does have that, he's on probation in South Dakota for a drug case, and he actually pled when he was out on bond on this matter in South Dakota. So it has no impact on his, he never failed to appear. He didn't commit a crime after being on bond or anything of that sort.
All right, thank you. So at this point, with regards to count 1, I'm going to set bond at $2,000. Not to have contact with minors under the age of 18 years of age other than his own biological children. With regards to count 2, I'm setting that at $2,000. Again, not to have contact with minors under the age of 18, but can have contact with his own biological children.
And he'll be allowed to return to South Dakota.
I don't believe the state objected to that. And correct?
No, Your Honor.
No, you objected, or no, you don't object?
No, Your Honor, state has no objection.
Okay. So the court has no objection to his returning back to the state of South Dakota, understanding that there has been representation by counsel, that he has good communication and control with his client with regards to making sure that he's going to return back to the state of Florida to deal with this case. And sir, this is relying heavily upon the reputation of your attorney. Your attorney is an individual with an impeccable reputation. And if he's saying that he will do whatever he can to make sure that you come back, I trust that. Don't let him down and don't let this court down. Right, sir?
Sí, señor.
Yes, sir.
All right. Thank you, counsel.
Thank you very much, Your Honor. Thank you for the kind words. Good seeing you again.
Thank you.
Seeing you.
Your Honor, is the interpreter still needed for any other cases, or may she disconnect?
Madam Clerk is indicating there's one more.
Yes, Your Honor.
Your Honor, Josue Reyes, his mental health.
All right, and so, Madam Interpreter, we will not be needing your services at this time. Thank you so much for your assistance.
Thank you, Your Honor, and it was a pleasure hearing from you again. It's so nice to see you. Hopefully, we'll see you at the courthouse.
You can see me?
Yes, I can see you.
You see all the hair I lost?
No, you look the same to me.
I wish I could see you, and please, I don't know if I'll be at the downtown courthouse, but if you have access to the jailhouse courthouse, it would be very nice to see you.
Likewise, but we don't travel anymore, so I'll have to hope that you will come to the courthouse.
All right, thank you.
Thank you. Bye-bye.
All right, so with regards to the case of Josue Reges, I'm appointing the Office of the Public Defender to represent him. And there are 3 counts. There is aggravated assault with a deadly weapon, aggravated battery with a deadly weapon, and carrying a concealed weapon. I've reviewed the charging document, find probable cause. Bond on count 1 is set at $2,500, count 2, $3,500, count 3, $500. Anything from the defense?
No, Your Honor, and I will waive the appearance.
Thank you.
Your Honor, so we just asked for no contact and no return.
All right, thank you. So there will be a no contact order with the alleged victim in the case, as well as a no return to the place where this incident took place. Please state your name.
Xavier Puckering, sir.
Thank you. And sir, you are here with regards to a charge of trespass on property after warning. I've reviewed the charging document and I find probable cause. I'm appointing the Office of the Public Defender to represent you.
It hasn't been filed. Hasn't been filed.
And Your Honor, the offer from the state on the trespass was an adjudication of guilt, credit time served and no return. And Mr. Puckering like to accept and enter a plea of no contest.
I'm showing that he's out on bond on a burglary of a dwelling and also out on bond on a trespass on property after warning.
Yes, the state has not filed, because I was just asking about a plea on the trespass. They have not made a filing decision. As far as the burglary, Your Honor, it's similar facts. He's sleeping. He's homeless, he's sleeping. So I just asked that because he's pleading to the trespass on the new law, that you take no action on the out on bond cases.
State, any comment?
Your Honor, given that it's not at the same location, state would request no action on the trespass and the burg dwelling if he pleads to the new law that he's being faced with today.
All right, and defense, are you aware of any possible ramifications for Mr. Puckering if he pleads on the trespass on property, the new charge? Will there be any impact on the 2 matters that he is out on bond on?
No, Your Honor, not that I know of, and he has a very limited criminal history. Only conviction that I see, other than his juvenile history, is a resisting without violence.
All right. Is he being held on anything else?
No, Your Honor.
All right, thank you. All right, can you please swear him in?
Oh, hold on, let me sign it. There you go. Thank you. Raise your right hand.
Thank you.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, sir.
Thank
Yes,
you.
ma'am.
Thank you.
Can you please state your full name?
Xavier Pokering.
And sir, did you review the plea form with your attorney?
Yes, ma'am. Yes, sir.
Do you understand the rights that appear on the front of the form?
Yes, sir.
Do you understand you are giving up those rights by entering a plea here today?
Yes, sir.
Do you understand the maximum and minimum penalties for the charge you are pleading here today on?
Yes, sir.
Are you entering the plea of your own free will?
Yes, sir.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
Oh, sir.
Do you understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes, sir.
Are you satisfied with the services of your attorney?
Yes, sir.
With regards to the charge of trespass on property, after warning from an incident of July 12th, 2022, how do you plea?
No contest, sir.
I accept the plea of no contest. I find you are alert and intelligent. You understand the rights and the penalties associated with the charge. You are entering the plea of your own free will, and there are sufficient facts to accept the plea. At this point, I'm going to adjudicate you guilty of the offense, give you credit for how much time served does he have?
2.
Give you credit for 2 days' time served. I'm going to require that you not return to the place where this incident took place. Which is I believe it's the 7-Eleven at 2160 Americana Boulevard. Is that correct, State?
Yes, Your Honor.
I'm going to impose upon you all applicable court costs and fees and require that they be paid within a 1-year period. You have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. With regards to the other 2 matters that you are out on bond on, I take no action.
Sir.
All right, thank you. Please state your name.
Marco Wilson.
I'm so sorry.
Marco Wilson.
Thank you. Sir, you are here with regards to a charge of burglary of a dwelling with damage above $1,000. I've reviewed the charging document. I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. Bond is set at $5,000. Anything, defense, state?
Your Honor, state would ask for no return, no contact, as it is a PBL, however, state's not asking for no bond at this time.
All right, and so we will require that you not return to the place where this incident took place, and that would be the address of 1613 Americana Boulevard. Is that correct, State?
Yes, Your Honor, it's the Cadence Apartments.
Cadence Apartments, and I'm going to require that you have no contact with the alleged victim or witnesses in this case. All right, thank you, sir. Yes, victims or witnesses, yeah.
Styles.
I don't have no way of paying now. My mom doesn't have no money. My checks are completely cut off. I don't have nothing. And I'm still trying to make appointments with Social Security so I could get myself turned back on. I don't have no way to live or nothing. Can't nobody bother me out. Period.
Let me just start by asking please state your name.
Yancey William Styles.
Thank you. You're here on a matter of a charge of, it's known as camping. I've reviewed the charging affidavit, find probable cause. I'm appointing the Office of the Public Defender to represent you. And counsel, I'm showing 4 different cases that he is out on some type of pretrial release or bond.
Yes, Your Honor, Mr. Stiles has been deemed incompetent to proceed, which is why he has the ROR, Your Honor. There was an offer, we cannot plead this case out. It's a camping charge. I would ask that you consider ROR and due to his incompetency issue, being that it's a non-violent offense. If he registers with e-notify on the court's website, he'll be able to get all of his court hearings sent directly to his phone so that the issue of him not appearing for court could be solved, Your Honor.
Is that something that you can help him with?
Yes, Your Honor.
All right.
We have him, he's well-known within our office, Your Honor,
Okay.
so we're able to help him.
And you're saying that he has been adjudicated incompetent by a court?
Yes, Your Honor.
All right. State?
Our state's only concern is he does have several recent failures to appear. However, I'll leave it within your discretion, given the charge is only a camping.
Do you agree that he's been found incompetent in a particular case or in a prior case with, by the court?
I believe in the 2019 CF 4132, I do see I do see orders appointing. 1 second, Your Honor.
And then, Your Honor, additionally on the drug possession charge, 2022 CF 19, for 8 AO, the state has not filed any formal charges, and that was back February 19th of this year.
Well,
I do see in the latest case, the 19 CF 4132, in front of Judge Strobridge, he has been found incompetent to proceed, and that competency status has been held
and I'm
through
sorry.
several hearings.
If you could maybe put the mic closer to you.
In the 19 CF 4132 case in front of Judge Strobridge, I do see that he has been found incompetent to proceed, and that status has been held through multiple different proceedings. With, I believe, one of the most recent evaluations being in March of this year. So state has no objection, you taking no action on all of his out on bonds.
All right, thank you. All right, so with regards to the case that brings him here today, the new offense, I am going to ROR him, but require him to maintain contact with the Office of the Public Defender
Yes,
at least
sir.
once a week.
Yes, sir.
All right, and then there is a system that they have that will send notices to your phone, so please make sure that they hook you up with that.
I wrote it on the form.
Yes, sir.
All right, thank you.
Thank you, sir. Yes, sir. Thank you. Have a good day.
Thank you. What case is counsel here on? Advancing this one? I can't really remember seeing the case.
No, my bag got stolen last night. I just unraveled with everything. Fell asleep, it got stolen. I have, you want my mother's phone number? Or, no, you don't want my mother's phone number. Yeah, I'm waiting, I'm waiting. I'm waiting on Simmons.
Excuse the interruption, but can I please have your name?
Sonia Reyes.
And you are here with regards to a charge of trespass on property after warning. I've reviewed the charging affidavit, find probable cause. I'm appointing the office of the
Unfortunately,
public.
yeah.
I'm appointing the office of the public defender to represent
I
you.
hear you.
Are you having trouble hearing me?
Yeah,
Do you need a hearing assistance device?
I do, but I don't have one.
Okay, they're going to get you the device, okay?
Okay.
All right, and so, can you hear me? Can you hear me?
No, something wrong.
Testing,
hear you
testing.
now.
Can you hear me now?
Something.
Testing, testing.
A little bit, that's better.
Can you hear me clearly now?
Yeah.
All right. And so you're here with regards to a charge of trespass on property after warning. I've reviewed the charging affidavit. I find probable cause. I am appointing the office of the public defender to represent you. Counsel, any comment?
Yes, Your Honor. Similarly, I would ask that you consider RR and Ms. Reyes on her out-on-bond case in 2020 and 6771AO. She has been deemed incompetent by a court to proceed. Given that she does not have a violent history and she was merely sitting at the bus station, she is transient. So I just ask that you would consider an ROR as long as she maintains contact with the public defender's office in the case, Your Honor.
State, any comment?
Your Honor, state will leave it within your discretion, given it is a nonviolent offense.
All right. And so in this particular case, Ms. Regis, I am going to release you ROR on the condition that you maintain constant contact with the Office of the Public Defender at least once a week.
Yes, sir.
All right. With regards to the matter that she is out on, I'm not going to take any action on that other matter.
The number's there, just call 120, right?
Because I can't
Oh,
see.
yes, ma'am. All right, for you.
And the name?
You don't have a name yet. When you call, they'll give you the name of the attorney, okay?
What case is counsel on? Private counsel?
Your Honor, Deanna Thomas.
This one? You're going to get through these, and then we'll get to that? I'm so,
Behavior, Your Honor.
I'm so sorry. Was that on Deanna Thomas?
Deanna Thomas, behavior.
All right. I am appointing the Office of the Public Defender to represent her. This is with regards to charge of battery. I have reviewed the charging affidavit, find probable cause. Bond is set at $500. I'm going to state any recommended conditions. This was an incident apparently at corrections.
At corrections, yes, Your Honor, just no contact with the victim. I'm assuming they've already been separated.
Right, and that was a, so yes, as a condition, no contact with the alleged victim in the case.
And I will waive the appearance.
Thank you. Then we have, please state your name.
Slendy Lewis.
Can you repeat that, please?
Slendy Lewis.
Thank you.
You're welcome.
You're here on a capias for failure to appear for a hearing on June the 16th, 2022. I am appointing the Office of the Public Defender to represent you. This particular matter has been set at a no bond status. Defense, do you have any comment?
No.
All right. Thank you, ma'am. Statewide prosecutor going to appear by video. We have an individual. Please state your name, sir.
Weston Jackson, sir.
I'm so sorry, please.
Weston Jackson. Jackson Weston.
Okay, perhaps if you get a little closer to the mic, or,
Weston Jackson.
all right, thank you. I'm having first, Storm Arterbury,
It's medical, Your Honor.
medical. The Office of the Public Defender has already been appointed in the case of Arterbury. Defense, he's in medical. What would you like to do?
I will waive and enter plea of not guilty, Your Honor.
All right, thank you.
Division 83, pretrial conference, August 1st at 8:30, courtroom 6C.
And thank you for your patience. Sir, you are Weston Jackson, correct?
Yeah.
All right, you have the Office of the Public Defender representing you. And counsel, any comment?
Your Honor, state did convey an offer to Mr. Jackson of an adjudication of guilt, credit time served, no return to Walgreens located at 160 South Orange, and cost of investigation to Orlando Police Department in the amount of $125.96.
And Your Honor, he's in comp proceedings, so I will enter plea of not guilty.
I'm good, I'm good. I'm not incompetent, no ma'am.
All right.
Good for that.
Okay, and so at this point, the prudent way to proceed, Mr. Jackson, is for me to accept the plea of not guilty.
I'm in the horizon over there, Wilder.
And Madam Clerk?
Division 61, pretrial conference, August 4th at 1:30 p.m., courtroom 7C.
Thank you, sir.
We see?
Judge, should I leave the do not return on there, or you don't want me to?
Everything that was on there before, leave it.
Okay.
And we have one more individual, Bryn.
You can leave him alone. They've already filed a notice of incompetency. He has to go through the process. I cannot leave him.
Please state your name.
Christopher Simmons.
Sir, you are represented by the Office of the Public Defender. This is with regards to the charge of petty theft. Defense, any comment?
I think there's an offer, I'm just.
I'll find Simmons. The state conveyed an offer to Mr. Simmons of an adjudication of guilt, credit time served, no return to, I believe it's the Walmart at 3101 West Princeton Street, and cost of investigation to Orlando Police Department in the amount of $83.48.
Your Honor, he would like to accept the state's offer and enter a plea of no contest. I did advise about the enhanceability of petty theft. He does understand. He would like to accept the state's offer here today.
All right. Can you please swear him in?
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
Can you please state your full name?
Christopher Simmons.
And, sir, did you review the plea form with your attorney?
Excuse me.
Did you review the plea form with your attorney?
Oh, yes, sir.
Let the record reflect the plea form was signed in open court. Thank you. And sir, do you understand the rights that appear on the front of the plea form?
Yes, sir.
You understand you're giving up those rights by entering a plea here today?
Yes, sir.
You understand the maximum and minimum penalties for the charge you are pleading here today on?
Yes, sir.
Are you entering the plea of your own free will?
Yes, sir.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
No, sir.
Do you suffer from any type of mental condition or disease that might affect your ability to think clearly?
No, sir.
Do you understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes, sir.
And are you presently under any type of probation or parole?
No, sir.
And are you satisfied with the services of your attorney?
Yes, sir.
With regards to the charge of petty theft, how do you plea?
No contest.
I accept the plea of no contest, find you are alert and intelligent, understand the rights and the penalties associated with the charge. You are entering the plea of your own free will, and there are sufficient facts to accept the plea.
Yes,
At this
sir.
point, I'm going to adjudicate you guilty of the offense. I'm going to give you credit for time served. The chart here is indicating you have 1 day on the ROR and 5 days on the failure to appear.
I'm not too sure, Your Honor. I'll have to refer to the clerk.
Is this correct, or
Oh, no, that's the clerk's on. I don't know.
who's? 6 days total, okay. I'm going to impose upon you all applicable court costs and fees, and I'm going to include cost of investigation of $83.48 to the Orlando Police Department, and require that you not return to the Walmart at 3101 West Princeton Street. And sir, you have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify.
Yes, sir.
Thank you.
Thank you.
Good afternoon, Your Honor. Attorney Scott Herman. I'm entering a oral notice of appearance on behalf of my client, Vishram Bajnath, B-A-I-J-N-A-U-T-H.
Your Honor, I believe statewide was going to appear virtually on this case. Do you mind turning on Cisco to make sure?
That's exactly correct. It's just stated
What was-
statewide.
Mr. Cooper?
Yes.
Are they going to?
Welcome to an Econo meeting. You are entering the meeting now.
Good afternoon.
Your Honor, that is not statewide. I recognize that individual as Defense Attorney Chris Akachunas.
Yes, sir.
How are you doing? Oh, there. So.
Hi, everybody. Good afternoon.
Good afternoon. We are actually looking for the statewide prosecutor. So how do I get him back into the waiting room?
These assistants.
I'm actually here on Iwani Ramsey, so when you're ready.
Good afternoon. We are.
The assistant statewide prosecutor who's been in contact with me and is online is Mitchell Cooper. Is there anyone else?
Good afternoon, Your Honor. Mitchell Cooper, statewide.
There he is.
All right. Are you on video conference or are you only on telephone?
My video does not like to cooperate, and it just doesn't have fun with that sometimes. So I'm sorry, Your Honor.
For what it's worth, Your Honor, as an officer of the court, I can identify the voice and inform the court that is Mitchell Cooper from the Office of Statewide Prosecution.
All right. And counsel, just for the record, I know you entered an oral notice of appearance. Is this just for today, or is it going to be notice in regards to representing him in this matter?
It is our intention to represent him throughout, not just for today.
Okay, and will you be submitting a written notice of appearance?
I can do that before the end of the day to the e-portal, Your
Right.
Honor.
Very good, thank you.
Thank you.
And so, did we lose Mr. Akachunas? All right. Is it Mr. Cooper?
Yes, Your Honor.
All right.
And Your Honor, this is a warrant that was submitted to the court and issued approximately 2 weeks ago. The warrant was $100,000 on count one, $100,000 on count two. My client's family did post that bond yesterday through a bondsman, but he was not released because of a separate order submitted by the Office of Statewide Prosecution requiring bank records shown that the posting of the bond was through legitimate funds and not funds obtained through illegal means. The bond was posted by my client's father, who's present. My client's father brought his W-2s, his bank records, everything. I have sent some of those over to statewide prosecution. I have more to provide to statewide prosecution. Statewide did ask me if I could potentially take testimony from the father, who's right there, that the money is his, obtained lawfully, and it was not given to him by my client, Mr. Bajnath. So if I could take brief testimony from the father.
And Mr. Cooper, is that your understanding?
It is, Your Honor. I have no preference if the defendant's father wants to write it down and have it notarized, or if the court wants to take testimony today. I'm not prepared to stipulate to that yet. I still need to review all of those documents that defense has submitted. But I hopefully I get those documents back this afternoon, and I'll be able to review those by the end of the day and submit a stipulation if everything's in order.
That's fine, Judge. It's easier for me if I could take testimony. I don't have an assistant today, so if I could take brief testimony rather than preparing an affidavit.
Do I need to push the button?
Good afternoon, everybody.
Good afternoon.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
We cannot hear.
To the microphone.
The truth to help me God.
Thank you. Please state your name for the record.
Jainarine Bajnath.
And sir, we need you to speak louder so that everyone can hear you. Speak right up to the microphone if you can. Can you state your full name again?
Jainarine Bajnath.
Okay. Mr. Cooper from Statewide, can you now hear him?
Yes, Your Honor.
Okay. Well, that was Attorney Scott Herman, not Your Honor.
Thank you.
No problem.
We sound alike.
Sir, what is your relation to Vishram Bajnath?
That's my son.
Okay. And did you post the $200,000 bond by providing approximately $20,000 to a bondsman within the last 24 hours?
Yes, sir.
Okay. And how did you get the funds in order to post the bond? Where did they come from?
Through honest and hardworking, through the bank account in my bank.
Okay. Mr. Cooper, he said honest, hard work through his bank account. Mr. Bajnath, did the money come from you personally?
Both me and my wife.
You and your wife, you both work for a living?
Yes, sir.
Okay. And they came out of your bank account?
We have a bank account jointly.
Okay. Did the money come from your son, the defendant Vishram Bajnath?
No, sir. Not
Okay.
a cent.
Did your son give you any money to post his bond?
No, sir.
Okay. I have no further questions for the father as it relates to the posting of the bond.
Mr. Cooper, do you have any questions?
I do not, Your Honor. As I said, I still need to review all the documents and everything just to make sure everything's in order.
I have a question.
Yes, sir.
If I may. And don't answer this question until defense counsel has an opportunity to say if there's any objection. I'm just curious as to whether or not the bonding agent required any collateral with regards to the rest. So if $20,000 was posted, that means that the bonding agent is putting $200,000, and sometimes they request collateral
Correct.
on the rest. So would you be able to ask him?
Well, I can ask, Mr. Bajnath, do you own your home?
Yes, sir.
Okay. And you're a resident of Orange County?
Yes, sir.
Okay. And did you provide that information to the bonding agent? That you
Yes, sir.
Okay. Judge, if I can inquire a little bit briefly, sir, your last name is Bajnath as well?
Yes, sir.
Where are you employed?
Orange County Public Schools.
And how long have you been an employee of OCPS?
21 years.
Okay. I don't have anything further, Your Honor.
Anything else, Mr. Cooper?
No, Your Honor. I just wanted to make sure that the court had the actual order that is attached to the capias. So there's the capias, which refers to the monetary amounts, and then there's another order, a separate order that has the special conditions. I just want to make sure the court has that order as well.
Yes, we have an order for capias, and it has special conditions. I don't need to read them off. I'm sure defense counsel has a copy as well.
I do have a copy, and I am currently showing it to my client who's present in the courtroom, what special conditions are required as he posts a bond. And as I stated, Your Honor, this bond amount was set back on July 5th. That the bond amount has been posted. All that is left to do is to satisfy the court that these are sufficient funds. I guess Mr. Cooper is reviewing bank records, W-2s. My only question is, and to Mr. Cooper and to Your Honor, if we can reach a stipulation later today is my goal. I'm guessing Your Honor, as a senior judge, is not going to be sticking around till 5 o'clock. Do we take that to a duty judge, or? I'm hopeful my client with no prior criminal history can get out later today. That's the goal here.
Understood.
Okay.
And so, by the looks of it, it's going to be a long day.
Okay.
And so, I'm looking at the clock, it's about 2:15. Do you think you might have this done by 4 o'clock?
So I have provided some things to Mr. Cooper. I have provided some additional items to the assistant statewide prosecutor who was just in the courtroom. I don't know if she left or where she went, but that's a question for Mr. Cooper. If he thinks we would have an agreement by 4 o'clock, that would be for the assistant statewide, I guess.
And if not, then it would have to be some type of duty judge after 5 o'clock.
Does Your Honor know who's the duty judge on duty, or where do I get that information? I hear Mr. Cooper typing. He might have access to it. They have.
Sorry, go ahead.
No, I'm just telling my client something real quick.
I believe it's Judge Wilson is the judge assigned to warrant signing, so we can just send it to her.
Judge Tanya Wilson?
I believe so.
Got it.
Okay.
Okay.
And so,
I don't know if there's anything we need to further address with Your Honor.
No, no, I don't think so. I think we've gotten everything, at least on the record. I appreciate the fact that the two of you are working together.
Yes, sir.
All that really is waiting is a stipulation or indication that there is no stipulation.
Yes, Your Honor.
With regards to this. So my best guess is I'll be here probably minimum through 3:30.
Okay.
Maybe that's wishful thinking.
Does Your Honor have a judicial assistant? Are you using another one, or how would we get an order to this court?
I'll write down the email of the JA that's covering.
There's a JA covering. Thank you.
Would that,
all right.
Is that Judge
Walker's JA?
Judge Walker's JA is covering for today?
Okay.
Okay, excellent. All right, thank you.
And then, Your Honor,
Yes.
I just want to make sure the jail has a policy where they'll accept an affidavit from a bondsman. I don't believe that that's appropriate given the order by Judge Blackman. Could you just please put on the record that the jail cannot release him until there's an order by the court, not by a bondsman?
That's up to the court.
Do you have no position on that, counsel?
Well, Your Honor, I'm not sure why statewide is requesting that, but I don't have an objection to that.
Okay. So there being no objection, I will agree to the request that he not be released until there's an order from the judge.
From a judge, understood.
Thank you, Your Honor. And I have one more. I'm not asking for it to be called. I just want the court to know so that way when it comes, you know I'm on video. It's Rayshard Brinson. And I'm going to put myself on mute whenever the court gets to it. I just wanted you to know that I'm also here for that case.
I believe that's the individual next in line.
And this is Chris Akachunas here. I'm here on Awani Ramsey whenever my case gets called up.
All right, thank you. Do we
Thank you, Judge.
know when his case is going to be called up? Ramson, is that correct?
Ramsey, R-A-M-S-A-Y. She's on page 5, bottom of page 5 of the afternoon session.
Is Mr. Cooper still on the line?
Yes, Your Honor.
Mr. Cooper, Madam Clerk wants to review some language with you that she's going to put on the sheet for today. With regards to the language that you had requested, can she read it to you and make sure that it complies with what you requested of this court and defense agreed to?
Yes, Your Honor. Thank you.
So this is, I gave it to you, but, no, did I give you the paperwork? No. This is what, understanding Mr. Cooper was requesting. The order for cases has conditions for release. All of that is here? Okay. Okay, Mr. Cooper, Madam Clerk
Yes, Your Honor.
is indicating that it would be easier for her if she can scan it and send it to you and make sure that it includes the wording that you and defense counsel wanted.
That works perfect for me, Your Honor. Madam Clerk, do you have my email address from the filings?
I'm ready. I can write it down now.
Okay, perfect. It's Mitchell.Cooper, so MITCHELL, the actual dot, Cooper, COOPER, at myfloridalegal.com, all spelled out, all one word, MYFLORIDALEGAL.com.
Thank you. I'm emailing it now.
Thank you very much.
All right, and then, sir, what's your name, please?
Rashard Brinson.
Thank you, and Mr. Akachunas, we have Mr. Brinson. And Mr. Cooper, are you also here on that case?
Yes, Your Honor. Mitchell Cooper covering for Rebecca Smith-Hameroff.
And Your Honor, I'm actually here on, her name is Iwani, EWANNIE,
Thank you.
and the last name is Ramsey, RAMSAY.
Okay, and so.
And she's on the bottom of page 5 of your afternoon IA session.
Got it. Thank you. Bear with me for a moment. So who is the defense counsel in Mr. Brinson's case? Does he have any so far? Do you have an attorney, sir?
No, sir.
Okay. And so, sir, let me just take care of this case. This is with regards to a warrant, a capias, with regards to 6 different counts. I'm appointing the Office of the Public Defender to represent you at this time. Count 1 is trafficking in, and I always have trouble pronouncing these words, but there are 1, 2, 3, 4, 5 counts of trafficking in phenethylamines, over 400 grams, and then the 6th count is possession of a firearm by a convicted felon. The judge who signed this capias set the bond on count one at $500,000 and the remaining 5 counts at $100,000 each. And defense, any comment at this time? State? Okay, no comments. All right, thank you, sir.
Your Honor,
Yes, sir.
I would also ask if you could announce the special conditions that are on the KPS as well as the order. The special conditions are to surrender the passport, not travel outside the state of Florida, have no contact directly or indirectly with co-defendants or witnesses, possess no firearms or weapons, possess or consume no alcohol or drugs. There is also a separate order in this case file, similar to the last case that was just called of mine, requiring that the defendant prove that the money used for bond come from a non-criminal source.
All right, and so I was, this wordage is already on your paperwork, Madam Clerk? The order, I don't see it attached here.
Your Honor, I know we had this case, we had Ashley Allen, which is also mentioned in this case earlier, last week, but I know the court granted that motion. In her case, I did not know that there was that the motion for Mr. Brinson was heard and granted that same day. I thought it was only as to Ashley Allen. So I'm not. Sure, because we objected then, but I'm not sure. I thought it was only heard as to Ashley Allen, not as to all the other defendants as of yet, Your Honor.
State, do you have any idea?
I wasn't able to hear that. I'm sorry, Your Honor.
So Ashley Allen, listed as Defendant D, was heard, the motion was heard where we objected to this motion then. However, I did not know that the motion was also being heard for this defendant at the exact same time, because I was not made aware of that when the judge signed the order for Ashley Allen. So I don't know if this was heard at the exact same time Ashley Allen was heard, because the only case we were addressing that day was as to Ashley Allen.
I don't have any information as to whether or not the motions were actually heard or if it was done at the time the warrants were signed. I believe that it was most likely done when the warrants were signed as part of the KPS.
July 6th. If that's the case, my only argument, Your Honor, was that at that time he wasn't represented by counsel, and he did not have, I would object as to, I feel it's a violation of his Sixth Amendment right to have counsel present when the motion was heard and the order was signed. Other than that, Your Honor, it has already been signed, so that would be my only objection to this issue, because I know we've seen Ashley Allen, but I didn't see any hearing for Mr. Brinson.
All right, and State, any comment?
No, Your Honor.
All right, I acknowledge, I will note the objection, I will deny it at this time, but without prejudice, as you have the
Yes, Your
right
Honor,
to bring it
I
up
understand.
with the division that it's been assigned to, okay?
Thank you.
All right. Anything else? Mr. Cooper, with regards to the order on, that you mentioned, with regards to the order on the KPS, I don't see one in the file. I see an order on bail conditions of release.
Yes, that's my
the-
objection,
okay.
because it was, Ashley Allen was heard that day, Your Honor, which is why I objected to him not having counsel. Ashley had counsel that day. He did not have counsel for that motion to be heard, as we didn't even address it that day.
And so,
Yeah, I'm looking at that. I pulled that up right when defense was mentioning it as well. Looks like this order is slightly different from the order in the case that was previously called, in that this does not require the proof of non-criminal origin. This order requires full collateral to be accepted. So it's slightly different than the previous one. So I apologize that I misstated that. I was pulling it up when defense counsel was talking and I noticed it then.
Okay, thank you.
all right. And so, with regards to the conditions in the case of Mr. Brinson, if Madam Clerk will make sure that the necessary paperwork indicates the conditions that appear and have been requested on the capias by the judge with regards to surrendering the passport, not to travel outside the state of Florida until further order of the court, no contact directly or indirectly with the victim or co-defendant or any state witnesses, not to possess, consume any alcohol or illegal drugs, or controlled substances without a valid prescription, and not to possess any weapons or firearms. Thank you.
And, Your Honor, was the verification of funds another?
He stated that it wasn't a requirement. It's just that he has to put up collateral. Is that correct? State?
That's what it appears to be when I'm looking at the order. It says that the entire monetary amount needs to be put up as collateral. So even if 20% is given to the bondsman, there needs to be collateral for the other 80%. That's what this order appears to state.
Okay.
Right. File an affidavit certifying that assignment of collateral to the trial court and listing such collateral and attaching copies of the assignment as proof. So that is what appears in the order of bail conditions of release signed by the judge. So that order is in effect.
Thank you.
All right.
Thank you, Your Honor. That's all I have. May I be excused?
Yes, thank you.
Thank you very much, Your Honor. Hope you have a good day.
Thank you, likewise. We have the Ramsey case next, correct?
Thank you, Judge.
Please state your name.
Yuani Ramsey.
All right, and counsel, can you please state your name for the record?
Absolutely, Your Honor. For the record, Christopher Akachunas representing Awani Ramsey.
And counsel, please proceed.
Your Honor, Ms. Ramsey was picked up on an Orange County warrant last week down in Broward County. She was extradited back to Orange. It's a 2-count warrant. Looks like count 1, conspiracy to commit armed robbery. Then count 2 is a principal in the first degree to aggravated battery. The warrant at this point being that she was extradited from Broward County, had a no bond, and we're here to discuss bond for Ms. Ramsey today. I'm not arguing probable cause for the warrant.
All right. And what is your argument with regards to bond?
Ms. Ramsey has no prior history, no failures to appear. She's from Orange County. She lives in Orange County. Her mom lives in Fort Lauderdale, Broward County. That's where she was at when she was picked up.
My client. Oh, stop. Let me see.
I was picked up in Palm Beach County, not Broward.
I guess he had.
Oh, okay.
he
I'm
had
sorry.
questions.
Palm Beach County. My apologies. 1 county down. Sorry.
Just don't, because I'm not your attorney. He is. Okay.
Mr. Akachunas, is it okay if the Assistant Public Defender stands next to your client as a friend of the court, just in case she has any?
Absolutely. I know with the virtual stuff it's a little difficult, but I have no objection to that. Absolutely.
Just that I have kind of divided
No, it's
attention, and so the screen where you are at is actually behind me. Your client is actually in front of me, and it puts her at a disadvantage if she's trying to say something and we don't notice it. But at least with the Assistant Public Defender standing next to her, if your client wishes to ask you something or say something, at least there's someone there to help, okay?
Absolutely. Thank you.
All right, and so.
But I guess I did misspeak that she was picked up in Palm Beach County on the warrant, but Ms. Ramsey does live in Orlando, Orange County.
All right. And so what are you requesting with regards to bonds?
I'd say reasonable bond amount, Judge. I haven't spoken to the state about this, but being that she has no FTAs, she is local, I'd ask for the bond schedule with maybe PTR conditions.
State?
Your Honor, state is concerned regarding the victim's safety as well as the community safety.
And
The
I'm-
victim,
Thank you, I appreciate that.
a state's concerned regarding the victim's safety as well as the community safety, as the allegations within the warrant are particularly troubling. The victim sustained several gunshot wounds to the abdomen. And it was a pretty elaborate scheme allegedly involving many other people.
Well, let me start with this. Is she entitled to have a bond?
She is, Your Honor. Count 1 is an F1. If it was just an armed robbery, it would be a PBL, but given a conspiracy, it knocked it down to solely an F1. Count 2 is an F2. I don't believe the bond schedule has either of these. Due to it being a principal and to being a conspiracy, it doesn't directly correlate. Understanding that Ms. Ramsey has no criminal history, but also taking into account the allegations within the warrant and the injury sustained by the victim. State would ask for 20 grand on count 1 and 10 grand on count 2.
Right, Mr. Akatunis?
Your Honor, at this point, I mean, this isn't a bond hearing, and I'm not sure of Miss Ramsey's financial ability to pay that, but you said 20,000 on count 1 and 10,000 on count 2?
That stays.
That was your recommendation?
That stays recommendation based off the bond schedule has robbery armed with a non-deadly weapon as a first degree felony at 10 grand. However, given that it was a deadly weapon, I doubled to 20,000 on that count. And I believe 10 was appropriate on the F2, given the injury sustained by the victim.
And Your Honor, I would agree with the state on count 2, 10,000, I think is reasonable. But on count 1, the state's asking for 20 because of, a victim's injuries or, the allegations. Ms. Ramsey's charged her. Hasn't been formally charged yet, but it's a conspiracy. And I would ask the court to do count 1 at 10,000 for a total bond of 20,000.
Now, Mr. Akachunas, you had mentioned before the possibility of a bond with PTR conditions.
Yes, I was wanting to see if the court would have a lower bond, but have Miss Awani Ramsey either call in or check in with PTR if the state's worried about the danger to the community.
Your Honor, given the charges, she wouldn't qualify for PTR, so PTR will not supervise her given the nature of the charges.
That was the question I was going to ask, whether or not PTR would agree to supervise.
No, Your Honor, they will not, given the level of felonies and the type of charge it is.
All right, thank you. Okay, and so I'm going to impose the following bond amounts. With regards to count 1, bond is set at $15,000. With regards to count 2, bond is set at $10,000. I'm going to require that you have no contact directly or indirectly with the alleged victim in the case or any witnesses in the case. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim. That includes the alleged victim's person, their residence, their vehicle, their place of employ, their place of worship, any educational institution that they attend. I'm going to require your consumer possess no alcohol or non-prescription drugs. I'm going to require that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. Anything else, Mr. Akachunas?
No, Your Honor, and thank you for allowing me to appear virtually with my conflict.
You're welcome. Anything else, State?
You okay? No, Your Honor.
All right, thank you.
Thank you.
Please state your name.
Luxon Calistin.
Sir, you're here on a charge of trespass on property after warning. I've reviewed the charging affidavit, find probable cause. I'm appointing the Office of the Public Defender to represent you. Counsel, any comment? Bond is set at $500. Any comment from the defense?
No, Your Honor, he has, regional conflict counsel on the out on bond. So I just ask that you appoint us only to the new law.
All right, and so we will appoint you to the new law matter with regards to the matters that had you out on bond. I'm going to revoke those and set it at a no bond status. Thank you, sir.
And as a friend of the
Yes, go ahead.
court, Your Honor, my only, I would only ask that given he has, I don't see any convictions. I see some arrests, but no convictions on his record. And the out on bond is different from the new law violation. However, both are nonviolent offenses. I would ask that you consider revoking and doubling as opposed to holding him at no bond.
I'm going to deny that and leave it at a no bond status. All right, thank you.
So you have to call RCC.
Please state your name.
Shantia Doherty.
You're here with regards to a charge of trespass on property after warning. I've reviewed the charging document, find probable cause. I'm appointing the Office of the Public Defender to represent you. Bond is set at $500. Any comment, counsel?
No, Your Honor.
All right, thank you very much.
400.
Please state your name. Your name, please.
Miriam Hayhead Gracia.
What's the last name?
Hayhead Gracia.
Gracia or Garcia?
Gracia.
State, just want to make sure we have the right person here. The document I have has her name as Garcia. She's indicating that her last name is Gracia, which is Gracia.
Yeah.
No, that's how it's spelled, Your Honor. I think it's just the way she pronounces it. It's spelled correctly. It's just the way she pronounced, the way it's pronounced.
Is it Garcia?
Correct.
So would you please pronounce it again?
Garcia. Gracia. It's both. You can see it both ways.
Oh, she just says it both ways, so it's Garcia or...
But it's Garcia.
It's Garcia. Okay, thank you. It's, all right. And counsel, I'm appointing the Office of the Public Defender to represent her at this time. Is there any comment?
Your Honor, I would ask that she be able to be screened for pretrial release. She was not able to be screened. So you can qualify, because I don't have any.
Any indication she might qualify?
Yes, Your Honor, she just needs to be interviewed first.
Okay, so this is what I'm going to do with regards to Ms. Garcia. I'm going to impose a $500 bond or PTR if she qualifies.
Any conditions, Your Honor?
With conditions. State, do you have any?
We would just ask for no drugs or alcohol, Your Honor.
Yeah, I don't see any. All right, thank you.
Jesse Ivy, mental health.
And I will waive the appearance, Your Honor. Just ask that based on the mental health issues, that he be screened for mental health pretrial release in addition to the bond,
All
or in
right, so I'm
conjunction.
appointing the Office of the Public Defender to represent him. This is with regards to a matter of false alarms or information, and the court will recommend it's a $500 bond or mental health pretrial release if he qualifies.
Thank you, Your Honor.
Okay.
Harry Perry, mental health, Your Honor.
And I will waive the appearance, Your Honor.
All right, I'm appointing the Office of the Public Defender to represent him. There is a charge of trespass on property after warning, a $500 bond. I've reviewed the charging document, find probable cause. He is out on bond on charges with regards to possession of firearm by a convicted felon, possession of ammunition by a convicted felon. I'm going to revoke on that and set that at a no bond.
Your Honor, state would also ask for a no return to the total wireless and the trespass case.
We will require that he not return to the place where this incident took place. All right, thank you.
Harrison Whitley, behavior.
I will waive the appearance, Your Honor.
Thank you. I'm appointing the Office of the Public Defender to represent him. Excuse me. This is a charge of trespassing on an occupied structure or conveyance. I've reviewed the charging document, find probable cause, bond is set at $500.
And Your Honor, as to the out on bond, I would ask that you take no action. There's a notice of non-filing that was filed in the case.
All right, and is that your understanding, State? This is a no file on the 2022 CF 5016?
He was ROR'd on June 7th, so approximately a month ago, due to us not having a filing decision yet, waiting on FDLE.
So nothing has been filed yet?
Nothing's been filed. It's still open, however, state has not filed an information.
Okay, I'll take no action on that. Right, no. Please state your name.
Bradley Carter.
You're here on a capias on a failure to appear with regards to a charge of petty theft. Bond has been set at $500. I'm appointing the Office of the Public Defender to represent you at this time.
Your Honor, state did convey an offer to Mr. Carter of a withhold, no return to Walmart at 5734 South OBT and court costs.
And Mr. Carter would like to accept and enter a plea of no contest. I also did explain the possibility of petty theft. He understands that. He'd like to accept the state's offer.
Mr. Carter was previously in pretrial diversion.
All right, thank you.
What was the location? I'm sorry.
Can you please swear him in?
Walmart?
It's Walmart at 5734 South OBT.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Thank you.
And sir, can you please state your full legal name?
Bradley Carter. Tyrone Carter.
And sir, did you review the plea form with your attorney?
Yes.
And do you understand the rights that appear on the front of the plea form?
Yes.
Do you understand the maximum and minimum penalties related to this charge?
Yes.
Are you entering the plea of your own free will?
Yes.
Under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
Yes.
And so let me ask that question again. Are you under the influence of any alcohol, drugs, or medication that might affect your ability to think clearly here today?
No.
Are you satisfied with the services of your attorney?
Yes.
With regards to the charge of, where it goes, petty theft?
Yes.
How do you plead?
No contest.
I accept the plea of no contest, find you are alert and intelligent, you understand the rights and the penalties associated with the charge. You're entering the plea of your own free will, and there are sufficient facts to accept the plea. At this point, I'm going to withhold adjudication on the charge. I'm going to require that you not return to the Walmart at 5734 South Orange Blossom Trail. I'm going to impose upon you all applicable court costs and fees and require that they be paid within 1 year. You have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify.
Thank you.
Thank you. There's no time served. Sir?
Angel Reyes Casalola, bonded.
Angel Casalora bonded. Okay, thank you. Please state your name.
Justin Ross.
Sir, you are here on a warrant or a capias on failure to appear for a case of disorderly conduct. I'm appointing the Office of the Public Defender to represent you. Bond on that is set at $2,000. Any comment, state? I'm sorry, state or defense?
No, Your Honor. You did make
All
it
right.
right.
And
I have an
so
offer on the,
you also
but not the.
are out on bond with regards to a charge of carrying a concealed firearm.
Not
And I'm going to revoke on that and set that at a no bond status. Thank you, sir.
Trespassers or bond
Your
on,
Honor,
or,
we should also have
No.
another
offer on the
case.
disorderly.
Got another case? Hold
No,
on,
wait, come
Mr.
back.
Ross.
I'm sorry. I was looking at the
A
wrong case. I am so sorry. You.
What
you're
else
making
are
an
you
offer
showing
on
for him?
The trespass and the failure to appear? That's what I was trying to figure out.
No, just the failure to appear disorderly, not the trespass, because it's a stolen vehicle one.
Oh, it's a car.
All right.
I'm sorry, Your Honor. I was still looking at Reyes. That's why it was a confusion.
Let me finish with the last matter, which is a charge of trespass and structure or conveyance. I've reviewed that charging affidavit, fine, probable cause, bond on that is set at $1,000.
On Ross, Your Honor, for the failure to appear on the disorderly, the offer is an adjudication of guilt. Credit time served, there is a $10 filing fee as well as court costs. Mr. Ross would like to accept and enter a plea of no contest.
That's on the disorderly.
Yes, Your Honor, the trespass, there wasn't an offer made because it was a vehicle. So I just asked that you, I believe you set the bond.
Well, let me just make clear that I'm still revoking on the carrying and setting that at a no bond status. Before I accept any plea, I want to make sure that that is clear.
You're still gonna revoke your on bond. Your Honor, if, and I know you were gonna revoke, but if he pleads to the failure to appear, and would you consider, as opposed to revoking him and holding him at no bond, revoking and doubling? He's
No,
self-employed.
no, I would not.
No, because he said no. So do you want to resolve it or wait? You're not gonna get out today. You want to resolve the failure to appear, though? Gotta wait for the attorney to file a motion downtown. If not more, I'll let the attorney know.
So is he wishing?
Yes, Your Honor, I'm sorry. He is, yes, he's going to go ahead and resolve the disorderly conduct.
And so we're only going to address then 2021
MO.
MO 825AO.
Correct, Your Honor.
Okay.
But I did miss, you said a $500 bond on the new law, correct?
That was a $2,000 bond on the failure to appear, and then on the trespassing, it was a $1,000
Okay.
bond.
I just want to give him the sheet. Thank you.
All right, so you want to,
He still wants to resolve the disorderly. He understands that he can't get out, that we have to file a motion to try to see.
okay. Is that your desire, sir? And the reason I ask is because sometimes if an individual knows that they're not going to leave the custody yet, it builds additional time in the way of credit where a package deal might be worked out with everything that's pending. Do you want to take a minute to talk to your attorney about that?
Yes, sir.
No. Yes, Your Honor, he understands. He would like to resolve just the disorder, the failure to appear the disorderly.
Very good, thank you. Can you please swear him in?
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Thank you.
And please state your name. And let the record reflect the plea form was signed in open court. Sir, that you go over this plea form with your attorney.
Yes, sir.
You understand the rights that appear on the front of the plea form? Do you understand you are giving up those rights by entering a plea here today? Do you understand the maximum and minimum penalties for the charge you are pleading here today on?
Yes, sir.
Are you entering the plea of your own free will?
Yes, sir.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
Yes, sir.
Do you suffer from any type of mental condition or disease that might affect your ability to think clearly?
No, sir.
You understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes, sir.
Are you satisfied with the services of your attorney?
Yes, sir.
With regards to the charge of disorderly conduct, how do you plea? In case number 2021MO825, how do you plea?
No contest.
I accept the plea of no contest. I find you are alert and intelligent. You understand the rights and the penalties associated with the charge. You are entering the plea of your own free will, and there are sufficient facts to accept the plea. At this point, I'm going to adjudicate you guilty of the offense. I'm going to give you credit for
3 days.
3 days' time served. I'm going to impose upon you all applicable court costs and fees. I'm going to add to that the $10 filing fee. We're going to put all of those together and have them paid within 1 year period. You have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. Thank you.
It's 1 year from release, correct?
1 year from release, correct. Yes.
I'm gonna write it right now.
Please state your name.
My name is Eric Larnell Holcomb.
And, sir, you are here on a charge of open container, reviewed the charging document, find probable cause. I don't know if the state gets involved in these.
Yes, Your Honor, state did convey an offer on behalf of the city of an adjudication, credit time served.
Your Honor, Mr. Holcomb has been deemed incompetent to proceed,
Okay,
so I cannot accept a plea.
all right, and just for purposes of the record, I'm appointing the Office of the Public Defender to represent you. Under the circumstances, I'm going to release him on ROR, but on the condition, sir, that you stay in constant contact with the Office of the Public Defender and that you communicate with them at least once a week, okay?
Okay. How many times is that? How many months? Oh.
Once it's over, then you can stop. You don't have to call us all. And attorney's number. So call.
Justin Carter, bonder, Your Honor.
Who was that?
Justin Carter.
Justin Carter. I had a Stewart, Kevin Stewart. Next. Okay.
220-16181.
Kevin bonded.
Okay, thank you. And then you're indicating that Carter bonded as well? Thank you. Your name, please?
Tyler Anderson.
And I'm sorry, what's the last name?
Anderson.
Thank you.
Just blackmail.
No, I'm saying, is this the one you were talking about? For a bond, or no? I know you said one you were okay with the bond. Was that the
It
other?
already went by.
You are here on a warrant that found probable cause with regards to 2 charges. Count 1 was burglary of a dwelling with assault or battery. Count 2 is grand theft, more than $750, less than $5,000. I'm appointing the Office of the Public Defender to represent you at this time. With regards to count 1, I'm setting bond at $5,000 to have no contact with the alleged victim or witnesses in the case.
Your Honor, state would object. Count 1 is a first-degree felony that's punishable by life. State would ask that count 1 be
Count
held at
one.
no bond. And there was a bond correction form filed on count 2,
Right.
setting it at 5,000. So state would ask that count 2 be at 5,000 and count 1 at none, with the standard no contact.
All right, you're indicating that count 1 is
A first-degree felony that's punishable by life.
He has a GPS detainer? Decent?
defense?
Oh, no, I was asking. He has a GPS detainer? Does Orange County do that?
No, that's from Seminole County.
He has to wait for Seminole to come? Is this a oh, I thought it was Orange County. I'm sorry. Your Honor, although it is a first-degree felony, you can use your discretion to set bond. The judge who signed the warrant did give you the discretion to modify at first appearance. So if you aren't inclined to set a bond, I would ask that you set a bond. He already has to have a GPS monitor on by Seminole County, so he's going to be monitored.
That's correct. The warrant did indicate that it may be modified by the first appearance judge.
Your Honor, it's always within your discretion on the PBLs. However, the legislator set them, given the nature of the charge, that it can be held no bond. And given the allegations within the warrant, they would ask that it be stayed at no bond, as it otherwise also came in with no bond. The judge who signed the warrant could have given a bond if they found it reasonable. So they would ask that it be stayed at no bond. And given the GPS, I understand that he'll otherwise be monitored. However, that'll be by Seminole County, not by Orange. So Orange won't have access to his whereabouts and what's going on with that case.
Does he have pending charges in Seminole?
Yes, Your Honor.
Do you know?
I believe that's the reason for the GPS.
You know what those are?
For the GPS, Your Honor, it's a battery domestic violence.
Oh, okay.
And I can't see that. I can't see.
I don't have access to Seminole.
Yeah, I don't have access.
All right, and so.
So I didn't know.
Yeah, no, that's important information there. That's important information. I was going to grant a bond amount, but under the circumstances, with the information that he is going to be monitored anyway, or that he has other matters in Seminole County, I am going to leave that at a no bond status with regards to count 1. Count 2 is a $5,000 bond. There will be conditions of not to possess or consume any alcohol or non-prescription drugs. But all of that can be picked up at the hearing at the, I imagine there's going to be a hearing on
Yes, it
trying to
will.
set a bond. Okay, well,
Thank you.
thank you.
Your Honor, state would also ask for no contact with the victim, just so we can't call her while he's in jail.
Yeah, he's not going to be leaving, and so I don't think I should do that now. I'll leave that if there's a bond hearing before.
Your Honor, state's concern about the no contact is him calling her while he's in jail.
Got it.
He'll still have access to contact with
Got
her.
it, okay. So,
So if they're
no,
always been like.
no, sir,
People just don't
no contact with the alleged victim in the case, directly or indirectly, so you cannot call them, text them, email them through any type of internet or social media platform as well. And you cannot have a third person try to communicate with them either, okay?
Thank
All
you,
right,
Your Honor.
thank you.
Also call the attorney.
Gunner James Booker is mental health.
And if you appoint, Your Honor, I will waive the appearance.
All right, I'm appointing the Office of the Public Defender to represent him. This is with regards to a charge of attempted burglary or of a dwelling. I've reviewed the charging affidavit, find probable cause, bond is set at $1,000. And not to return to the place where this incident took place. Please state your name.
Cedric Brown.
All right, sir. You are here with regards to a few matters. One is an arrest affidavit alleging sale or delivery of MDMA and delivery of meth within 1,000 feet of a place of worship. I'm appointing the Office of the Public Defender to represent you. State, I need a bit of clarification here. When I reviewed the arrest affidavit, I was looking for the sale and delivery. What I read is an incident where two individuals are sitting. I think what the affidavit is trying to say is that when he gave the blunt to the other individual, that was the sale or delivery?
Yes, Your Honor, my understanding is the jury instruction reads sold, manufactured, delivered, possessed, manufactured. So I believe it is the passing from one person to another. It doesn't have to be a sale, it can be solely that delivery. And then the second charge, while it seems a bit redundant, however, it adds the temporal and location to that church. While I believe there's PC for it, I believe the bond amounts don't reflect the allegations within the warrant or within the affidavit. So state would ask that you find PC, but significantly decrease the bond amount that it came in as, because I don't believe it accurately reflects the allegations within the affidavit.
Defense?
I did research the issue, and I believe the state is correct. It is the passing of the drugs. However, Your Honor, given that fact, I would ask that you set bond as if it was a possession charge, because I don't believe the state will go forward on the sell and delivery merely based on that.
All right. Thank you for both of your input. At this point, with regards to count one, the sale and delivery of MDMA, I'm putting that at, I don't have a bond schedule on me. What's the?
A simple possession is generally at 1,000.
Thank you. $1,000 bond on that. And then with the count two of being within 1,000 feet of a place of worship, we'll put that at $1,000 as well. Then you have a matter of an open container, and that bond is set at $250.
Thank you.
Anything else, State Defense?
No, Your Honor.
No, Your
Thank
Honor.
you. You're welcome, sir. Please state your name.
First name Corbin, last name Bush.
Thank you. You're here on two charges. First one is a charge of burglary of a dwelling. Second is a charge of criminal mischief. I've reviewed the charging affidavit, find probable cause. I'm appointing the Office of the Public Defender to represent you. Bond on count one is set at $5,000, count two at $100. Any comment from the State or Defense?
Your Honor, state would ask for no return to the residence and no contact with the victim, Ms. Lamb.
And any comment from the Defense?
No, Your Honor.
All right, I will require, sir, that you not return to the place where this incident took place, and also require that you have no contact directly or indirectly with any alleged victim or witness in this case. Thank you, sir. Please state your name.
Darnell Daniels.
Sorry, what's the last name?
Daniels.
Thank you. This is the other individual involved in
Yes, Your
that
Honor.
situation. Am I going to hear the same arguments?
Yes, Your Honor, state would
Yes.
just renew all the same arguments to treat it as a
Okay,
possession.
thank you.
Same for defense.
All right, and so, Mr. Daniels, you are here with regards to a charge of delivery of meth within 1,000 feet of a place of worship. We have discussed already the issue with regards to probable cause. The court will find probable cause at this time. And I'm going to impose a bond amount of $1,000 in this case. Any other conditions, State?
No, Your Honor.
And then with regards to the other matter, you have an open container charge, and bond on that is set at $250. And if I didn't say it before, the Office of the Public Defender is appointed at this time to represent you. Okay, sir?
Thank you, Your Honor.
No. Right. No, thank you for asking.
Okay.
Please state your name.
Joel Dozier.
Dozier?
Yes, sir.
Right, thank you. Sir, you're here on two charges. First is a charge of burglary of a conveyance. Second is a charge of resisting officer without violence. I'm appointing the Office of the Public Defender to represent you at this time. I've reviewed the charging document and find probable cause. Bond on count one is set at $3,500, and on count two is set at $100. Any comment from the state or defense?
Your Honor, state would ask for a no return to the Hidden Creek Apartments and no contact with his co-defendants.
Any comment from the defense?
No, Your Honor.
All right, and sir, I am going to require that you not return to the place where this incident took place. I'm also going to require that you have no contact directly or indirectly with any of the co-defendants in this case. You understand what I've said?
Yes, sir.
All right, thank you, sir.
Your Honor, Joseph Jorman bonded.
Thank you. Please state your name.
Tiffany Enos.
You're here on an arrest warrant with regards to a charge of possession of methamphetamine. The judge set this at a $1,000 bond, not to possess drugs or medications without valid prescription. I'm appointing the Office of the Public Defender to represent you at this time. Any comment from the state or defense?
No, Your Honor.
Please state your name.
Adrius Flores Jr.
And I'm sorry, please repeat that.
Adrius Flores Jr.
Thank you. Is there an Adrius Flores Sr.?
Yes, sir.
And the reason I inquire, state, is that
I already made note regarding the name, Your Honor.
I'm sorry?
Already made note regarding the name to add junior.
Okay, because he's junior, but the document attached indicating that there was someone released PTD on another charge indicates it's a senior. So who can clarify this for me? There is an indication that a Eridis Flores Senior was out on PTD on the charge of possession of Utilone.
Do you have a case number, Your Honor?
Surely. It is 2020 CF 14548AO.
That is, I have that as Mr. Flores Jr., same date of birth.
Okay,
as his
1988.
case. A possession of Utilone, 20 CF 14548.
Okay, so it's, I just want to make sure that it was a typo and not. that
Yes,
we-
Your Honor.
Okay,
I
so,
do believe it is this defendant, the junior.
all right, and the date of birth is October 17th, 1988 state?
Yes, Your Honor.
Okay, thank you. All right, sir. I'm appointing the Office of the Public Defender to represent you. You are here on two matters. Count one is possession of MDMA ecstasy. Count two is possession of cannabis under 20 grams. I've reviewed the charging document and I find probable cause. Bond on count one is set at $1,000. Count two is set at $100. With regards to the matter that you were out on PTD on, any comment, defense?
Your Honor, he was in pretrial diversion. It's gone inactive. I don't know what he had left. I'm trying to see if our system will say. But I would ask that, given it's a nonviolent offense and he was in pretrial diversion, that you take no action. If the state wants to revoke the pretrial diversion, they could file a motion, Your Honor.
It's been in PTD since March of 2021, so it's been approximately a year and a half within drug diversion PTD, which is watching a video and paying fines. And I don't have any notice of anything being completed. I'm assuming PTD is most likely going to be revoked because it's been a year and a half to watch a video and it has not been completed to date.
All right. Okay, with regards to the case number 2020-CF14548AO, I'm going to revoke on that.
Your Honor, he did. Actually, I'm reading the notes. He watched the video. The only thing,
Bear with me because he has his hand up. So do you want to talk to him first?
he was gonna say the same thing. You can put it down. Just give me a second first. He only had 196 to pay, that was the remaining amount that he had to pay. I'm coming. I'm just reading the email. And that was January of this year was the last note I had.
Basically, I was saying, I just.
This one?
So yes, Your Honor, he did do the 4-hour class. The only thing that was left was the amount he had to pay. He just recently got a job, which is what he was stating. I just wanted to make sure he wasn't saying anything on record that would hurt his case. Your Honor, he just got his job. The only thing he had to pay was the 196 that was left, which is what he's going to work on paying. Well, now he's probably going to be kicked out, but he did comply with the 4-hour course. And so I would ask that you take no action on the out on bond case, given that it's a nonviolent offense. He doesn't have a relatively violent history, Your Honor.
I'm going to revoke on the PTD release, and I'm going to set a bond of $1,500.
Can you file that and give it to the state? Because we don't have anything.
It's in our system. I'll let the attorney know. 'Cause they close it once they go to PTD, which is weird. And I'm sorry, I missed the other bonds. Do you have it?
It was 1,000 or 100 on the new law, and then 1,500 on the out on bond.
Please state your name.
My name is Mario Garcia.
Sir, you are here on a warrant arrest with regards to a charge of written threats to kill or do bodily harm. I'm appointing the Office of the Public Defender to represent you. Bond on that was set at $3,500. You also have charges. No, that's it. That's all. That's everything for Mr. Garcia, correct?
Yeah, Sharon, that's all he's here on today. State's just concerned regarding him being a flight risk. He has a warrant out of Georgia for a failure to appear. He was extradited here from New York. But state would just ask for a no return to the Taco Bell and a no contact with the victim, Mr. Knight.
Right. I also see on the warrant, so I will agree to those conditions. No return to the Taco Bell as mentioned. No contact with any of the victims, and do not possess or control any weapons or firearms. All right, thank you, sir. Please state your name.
George Gaston.
Sir, can you please state your full legal name?
George Gaston.
Are you, and there's a reason why I'm asking for your full name.
George Stephen Gaston, Jr.
All right, thank you, sir. Sir, you are here on a warrant with regards to charges of dealing in stolen property, violation of Florida Pawnbroker Act, and petty theft. The warrant sets bond on count 1 as $1,500, count 2, $3,000, count 3, $500, with special conditions that you not return to the location where this incident took place, and that you not return to any pawn shop. I'm appointing the Office of the Public Defender to represent you. All right, any comments, State Defense?
No, Your Honor.
No, Your Honor.
Thank you. Please state your name.
A.B. Moses Harold.
Sir, you are here with regards to Acapius on a charge of grand theft third degree. Bond on that has been set at $2,500 with conditions of having no contact directly with the victim, co-defendants, or witnesses in this case, that you not return to the scene of this offense, and that you not possess any weapons or firearms. I'm appointing the Office of the Public Defender to represent you. Any comments, State Defense? Oh, I'm sorry, bond is set at $2,500.
I think it's another case.
You're not on that case, his other case.
Thank you. Not on this case.
Yes, you asked if the state had any comments only on his next case.
Got it. Thank you. Sir, you're also here on matters regarding a arrest warrant on a charge of robbery with a firearm. The judge has set that at a no bond status, may be modified by the first appearance judge. That warrant also indicates that you're to have no contact with the alleged victim in the case and no return to the place where this incident took place. The state?
Your Honor, given that it is a first-degree felony that's punishable by life, state's requesting that it remain at no bond pending an Arthur hearing downtown.
Defense, I'm appointing the Office of the Public Defender to represent you, sir. Defense?
Your Honor, you do have the discretion to set bond, so I actually use that discretion. He has been deemed a competent to proceed in all of his cases, Your Honor. So even if you don't set a bond on the robbery with a firearm, I would at least ask you take no action on the out on bonds, as all of them have been filed, and they are all in comp proceedings.
And so I've got 1, 2, 3, 4, 5, 6, 7 different matters that he is out on either bond or oral on. Are you saying that in all of those cases he has been found incompetent to proceed?
Yes, Your Honor.
And state, any comment?
Your Honor, I looked up the latest one, the 2021 8060. I did see there was a motion to continue finding of IT
incompetence.
Our state was just requesting you take no action on his out on bonds, and hold him no bond for the time being in the robbery with a firearm, so there's circuit judge can figure out what to do with that case.
All right, thank you. And so at this point, I'm going to leave the present defense at a no bond status, and then I will take no action on the other matters that he is out on release. Please state your name.
Brian J. Jones.
All right, sir, you are here on 2 charges. One is driving with license suspended or revoked as a habitual offender. Second is a charge of possession.
No, that's not me, sir.
Hold on. I just need to make you aware that everything you say is being recorded and can be used against you. I am going to appoint the Office of the Public Defender to represent you at this time. All right? So let me let you know that you are here on a charge of driving with license suspended.
Your Honor, I believe this is Mr. Jones.
This is Jones.
Burke structure criminal mischief.
Mr. Jones?
Yes.
All right, what happened to Mr.?
Johnson?
Yes, thank you. Excuse me, Mr. Jones.
Yes.
All right. Mr. Jones, you are here on two charges. First is a charge of burglary of a structure. Second is a charge of criminal mischief. I'm appointing the Office of the Public Defender to represent you. I'm finding probable cause for the charges. Bond on count one is set at $3,500. Count two is set at $100. Any comment from the state or defense at this time?
Your Honor, state would ask for a no return to the address and no contact with Brianna Jones, the victim. And state would also request no action on the out on bond as state has not filed.
All right.
That was all that I was going to say.
All right, thank you. And so I will agree to the conditions mentioned by the state, which is a no contact and a no return. And take no action with regards to the charge of possession of cocaine on which he is out on. Please state your name. Please state your name.
I'm Ryan Edward Carson.
Thank you. Sir, you are here on two charges. First is a charge of carrying a concealed weapon by a convicted felon. Second is a charge of petty theft. I've reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you. Bond on count one is set at $5,000. Count two is set at $250. Is there any comment from the state or defense?
State would just ask for a no return to the target.
And I'll require that you not return to the target where this incident took place. Anything else from the defense?
No, Your Honor.
All right, thank you, sir.
Jasmine Lane, refuse, Your Honor.
Thank you. All right, with regards to the case of Jasmine Lane, I have reviewed the charging affidavit, find probable cause for the charge of possession of cocaine. Bond is set at $1,000, and the Office of the Public Defender is being appointed to represent her.
And I will waive the appearance, Your Honor.
All right, thank you. And please state your name.
Justin Polk.
You are here on a warrant arrest with regards to a charge of grand theft, third-degree motor vehicle. The judge in that case, on that warrant, set the bond at $5,000. I am appointing the Office of the Public Defender to represent you. There is also conditions that you have no contact with the alleged victim in the case and that you not return to the place where this incident took place. Also that you possess or control no weapons or firearms. Is there anything else from the state or defense?
No, Your Honor.
No, Your Honor.
All right, thank you, sir.
Melody Rich, refuse.
Thank you. With regards to the matters of Melody Rich, I'm appointing the Office of the Public Defender to represent her. There is a capias for arrest on a charge of trafficking in 4 grams or more of fentanyl. The judge set that at a $100,000 bond. Count 2, unlawful use of a two-way communication device. That bond was set at $150.
And I will waive the appearance, Your Honor.
Thank you. Then the other matter that she is here on are charges of criminal mischief. Bond is set at $500. Battery, bond is set at $100, and resisting officer without violence, bond is set at $100. I had reviewed the charging affidavit, found probable cause, and have appointed the Office of the Public Defender to represent her on those matters.
Your Honor, state would ask for a no return, no contact.
All right, and we will require that she not return to the place where this incident took place, and that she have no contact with the alleged victim or witnesses in this case. Thank you. Please state your name.
Lee Thomas Rivers Jr., please, sir.
Bear with me for a moment, please. I know I have it.
You have a copy of information sheet?
It's okay. Here it goes. I
Oh,
found
you
it.
found it.
Yeah, it's not in the order. All right, sir, you are here on certain matters. I'm going to appoint the Office of the Public Defender to represent you. This is with regards to case 2022 CF 8077AO. Defense counsel, do you want me to read the charges?
I'll waive the reading, Your Honor.
All right, thank you. With regards to count one, any comment from the state?
Your Honor, he is entitled to a bond. However, state would just bring your attention to that he is a registered sex offender. And given that these are sexual in nature offenses, state would ask that you take that into account. Also regarding the battery, it arguably was a standard battery, but also a battery by strangulation. So state would also ask that you take that into account when setting the bond on that and not treat it as a subsidiary. And state would also ask that you take into account his last failure to appear was approximately 2-3 years ago. So state's concerned regarding, one, him being a sex offender and committing a new sexual offense, allegedly, a recent failure to appear, and his last convictions were also failures to comply with court orders and maintain his sexual reporting offender status. So state would just ask that you take that into account when setting his bond. Given that we don't have the victim's testimony here today, I do believe they were roommates. The allegations within the affidavit are particularly troubling to the state, Your Honor.
Defense? And if I didn't make it clear, I'm appointing the Office of the Public Defender to represent him at this time.
Okay, Your Honor, I just would waive the reading of any of the charges, Your Honor, today.
Okay, thank you. And so, as I said, I've reviewed this. I find probable cause with regards to count one. I'm going to set bond at $15,000 to maintain a separate residence, have no contact with the alleged victim in the case. That means that you cannot talk to this person face-to-face, call them, text them, email them, or try to communicate with them by a third person or any type of social media platform. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim. That's 500 feet away from her person, her place of residence, any vehicle she may have, any employment she may have, or place of employment that she works at, place of worship that she attends, any educational institution she may belong to, and any store that you know this person frequents. With regards to, I'm also going to require that you possess or consume no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. With regards to the count two on the battery, I am going to set that bond at $2,500. Same conditions imposed as I did on count number one. And then with regards to count three, the false imprisonment, it'll be a bond of $3,000 along with the same conditions I impose in counts 1 and 2.
Your Honor, state would request a one-time return due to them living together, since you ordered the separate residences. And state would also request a no contact with the witnesses, as I believe a lot of the roommates saw or heard
All right.
this allegation.
Okay, and so I will allow you to return one time with the assistance of law enforcement in order to retrieve personal belongings. And then I'm going to require that you have no contact directly or indirectly with any of the witnesses involved in this matter. All right, thank you. Please state your name.
Stephen Rolon.
Your full name, please.
Stephen Alex Rolon.
And are you a junior or a senior?
Junior.
All right. Sir, you are here on a warrant with regards to charges of shooting into an occupied vehicle. The judge who signed the warrant set bond on that at $50,000. Count 2 is possession of a firearm or ammunition by a convicted felon. That bond was set at $5,000. Count 3 is criminal mischief, over $1,000. Bond was set at $1,000 on that. Count 4 is culpable negligence. Bond on that is set at $1,000. Count 5 is reckless display of a firearm. Bond on that is set at $2,500. And count 6 is unlawful discharge of a firearm in public. Bond on that was set at $2,500. I'm appointing the Office of the Public Defender to represent you at this time. Any comment from the state or defense?
Your Honor, state would ask for no contact with the victims or witnesses, no weapons.
All right. And sir, I'm going to require that you have no contact directly or indirectly with any of the witnesses involved in this matter, and that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. Thank you, sir.
You have any questions?
Please state your name. Yeah, please state your name, sir.
Nelson Santiago.
All right, sir, you are here on a capias, on a failure to appear, on a charge of possession of cocaine. Bond on that was set at $1,500. I'm appointing the Office of the Public Defender to represent you.
Thank you, Your Honor.
Is there any comment from the state or defense?
No, Your Honor.
All right, thank you.
I'm done.
You're welcome, sir. Please state your name, sir.
Kalen Smith.
I'm so sorry.
Kalen Smith.
Thank you. You are here on a warrant with regards to 2 counts. Count 1 is conspiracy to commit armed robbery. Count 2 is principal in first degree to aggravated battery. The judge has set those at no bond status. Any comment from the state or defense?
Your Honor, this is the co-defendant of one of the defendants from earlier. Count 1 is an F1, count 2 is an F2. I believe Mr. Smith has no criminal history, much like his co-defendant earlier. So state would just ask that you set bonds that are consistent with his co-defendant.
I can't remember what it was.
And I'm
I believe it
appointing,
was 15 and 10, I believe.
that was,
The private counsel, correct?
right, that was Mr. Akachunas' case.
Yes.
And so, and I'm not sure, it's been a long day. Just in
Yes.
case I didn't say that I've appointed the Office of the Public Defender to represent you. I am appointing them to represent you at this time. And,
Yes, Your Honor. State would ask for the same conditions, given that Mr. Smith has no criminal history, much like his co-defendant, Ms. Ramsey. And set 15,000 on one, 10,000 on two, and set the same conditions of no contact with the victims or witnesses or co-defendants, stay 500 feet away from victim, no alcohol and drugs, and no weapons.
all right. And any comment from the defense?
No objection.
All right. And so at this point, with regards to count one, conspiracy to commit armed robbery, bond is set at $15,000. Count two, principal and first degree of aggravated battery, bond is set at $10,000. I'm going to require that you have no contact whatsoever, directly or indirectly, with the alleged victim in the case or any of the witnesses involved in this case. I'm going to require that you possess or consume no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victims in this case. That be 500 feet away from their person, their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know they frequent. Anything else, State, Defense?
No, Your Honor.
All right, thank you, sir.
Thank you, Your Honor.
You're welcome, sir.
The Norris Albert, bonded